So welcome. They gave it to you, dude. Unbelievable.
Hey, thank you, Mr. Gomez.
You're welcome.
All rise, please. Circuit Court is now in session. Honorable William F. Stone presiding.
Good morning. Please be seated. Good morning, Mr. Swiatek.
Morning, Your Honor. Your Honor, may I approach?
Granted. Does Mr. Wilson?
Mr. Wilson, this is a plea agreement and score sheet. Review score sheet, stipulate the same.
All right. Announce the terms and conditions, please.
Mr. Wilson is here in case numbers 21 CF 1520, which is a VOP, and then new law charges 23 CF 2077, 23 CF 2835, 2836, 2837, 2838, 2839, 24 CF 201, 24 CF 239, 467, 468, 469, 487, and 488. We have a downward departure plea agreement based on an uncoerced plea. Mr. Wilson will be sentenced to a total of 60 months with credit for time served. Probation will be terminated, revoked and terminated probation.
Yeah, she'll be sentenced to 1 year incarceration in the Okaloosa County Jail, listing her house throughout the agreement. All that is concurrent. So the intention is to 1-5 year Department of Corrections sentence and the maximum of the misdemeanors concurrent. The court costs are included in the plea agreement. There's $515 in each case. Madam Clerk, I believe that is 13 total cases. That's going to be the equivalent of about $6,695 in court costs. There's a $100 BOP fee, a $50 public defender application fee, and a total of 7 costs of defense, which would be a total of $700. The restitution is also included in the plea agreement, and is broken down by case number, including the amount, the victim and their addresses. Does the court wish for me to announce all the restitution information?
Well, the state's reviewed the plea agreement. There's a lot in there, and those restitution amounts within the plea agreement are accurate, as is the names, and it appears, Madam Clerk, that the names and the physical addresses are all listed in the plea agreement.
Yes, sir. Defense counsel and I went over those together as we were preparing the written plea agreement. I've reviewed it. Yes, sir.
All right.
Judge, the intention is to send all the financials to civil lien or judgment.
All right,
There's adjudication of guilt on all counts.
all right. And so I'm showing, just to be sure, Madam Clerk, we've got 21, 15, 20, 23, 2077, 23, 28, 35, 23, 28, 36, 23, 28, 37, 23, 28, 38, 23, 28, 39, 24, 201, 24, 239, 24, 267, 24, 468, 24, 469, 24, 487, 24, 488.
So I believe that was 24 CF 467.
467,
Correct.
468, 469, 487, and 488.
Correct.
Does that cover them all, Madam Clerk? Okay, all right. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury? All right, and you put your hand down. You heard what Mr. Switek and what Mr. McKinney said just now regarding this plea agreement.
Yes, sir.
And they've tendered me this plea agreement which claims to have your signature. Did you sign this?
Yes, sir.
And how old are you and how far did you go in school?
21, completed high school.
All right. You able to read and understand the plea form?
Yes, sir.
And did you do that before you signed it?
Yes, sir.
And is what you read in the plea form what Mr. Switek and Mr. McKinney announced on your behalf?
Yes, sir.
Now, you got two things going on today. You got your violation and your new charges, but we're taking care of them together. They're two different things. Do you understand that?
Yes, sir.
All right, as to your violation, do you understand you're admitting the violation?
Yes, sir.
And by admitting that, you're telling me that I violated my probation just the way the affidavit report says it did. And by making this plea, do you understand you're waiving your right to a hearing where the state would have to prove your violation?
Yes, sir.
And as to your new charges, do you understand you're pleading no contest?
Yes, sir.
And that says to me, you believe the state has the evidence necessary to convict you of these charges and you don't intend to contest that.
Yes, sir.
Okay, now if you need a minute to ask your lawyer to be sure. Okay, and do you understand by making this plea, you're waiving your right to a trial
Yes, sir.
where the state would have to prove your guilt beyond a reasonable doubt in front of a jury?
Yes, sir.
Now, between Mr. Switek and Mr. McKinney, have they answered all your questions about this plea and how it affects you?
Yes, sir.
And are you satisfied with how they represented you?
Yes, sir.
You're going to be adjudicated guilty on all of these counts. You're going to have a substantial amount of court costs and a substantial amount of restitution that is going to be due. They've announced that they intend to send those financials to collections or to a civil lien, which means that you don't have a current obligation to make those payments. However, those civil liens and those collections may have some impact on you after you come out of your incarcerative sentence. If you wish to make payments or other arrangements, all you need to do is reach out to your lawyers and they'll tell me and I'll set up an arrangement for you to make payments, which may help you with any adverse impact that those collections or civil liens may have, okay?
Yes, sir.
All you need to do is ask and we'll try to work with you to make sure. The goal will be to get those things paid, which could take some of those adverse consequences away from you.
Yes, sir. Thank you.
Now, with that, you understand that with this plea, you're serving 5 years in the Department of Corrections, credit for all time served.
Yes, sir.
And you have 1 year in the Okaloosa County Jail, but those are concurrent with all the other charges.
Yes, sir.
Your probation will be revoked and terminated. And the state agrees that this is a downward departure and it's appropriate to depart downward based upon your agreement to take this plea. Is that what you understood?
Yes, sir.
The court will find the plea to be freely and voluntarily entered into and will accept the plea with the adjudication.
And the judge, to be completely redundant, that is all counts concurrent with credit for all time served.
All counts concurrent, credit for all time served.
Thank you, sir.
Thank you, Your Honor.
So I know the restitution is going to be over to the civil lien, will the clerk take payment?
Say again?
Will the clerk take payment on the restitution?
Yes. Mr. Cobb?
Not in here.
Mr. Flowers?
There's Mr. Flowers.
Yes, sir.
Your Honor, good morning, sir.
Good morning, Mr. Flowers.
Your Honor, before I take up the matters in my name, Mr. Dyram has 3 matters before the court, and if it please the court, I told him I would take up those matters for him today.
All right.
The first is, and I'm going to pronounce it, Mollenhauer.
Your Honor, I can update the court on this. I spoke with Mr. Dyram on Friday. This is a case where we are simply wanting Mr. Mollenhauer to complete his payments, and then we're going to honor the original PTI agreement and dismiss the case. In speaking with Mr. Dyram, I think both sides would be requesting a continuance of 5/12 with the intent being that he's going to pay off the remaining amounts there, and then we are going to dismiss the case.
Your Honor, that's what Mr. Dyram told me too. I'm not surprised to hear that, but that's the scenario.
All right, so one more continuance is what we're saying?
Yes, sir, Your Honor.
And that's a full continuance to the full cycle? And then if
5/12.
Yes, Your
and
Honor.
if it's resolved otherwise, then we'll take, y'all let us know. Is that what
Yes,
we're
I'll
saying?
follow dismissal, Your Honor.
All right, very
Thank
good.
you, Judge. The next matter is Patricia Roberts. Misdemeanor plea was filed this past Friday. If the clerk's office doesn't reflect that, that is what happened.
That's correct, yes.
Madam Clerk?
I do not see that in this yet.
Let's see if it's in my queue.
If it's not there, it'll be there shortly. I'll look to see if it was waiting on a approved button. He pushed to my office in stack. I'll look. But I signed it and scanned it and had my assistant e-file it Friday is what I thought happened, so. But we have reached an agreement and
So you've seen it and the agreement is there, so we would just need to set it for a status? Is that what we're
that's
essentially
fine.
saying?
It's going to come off the docket here today, so, yes, sir.
And Your Honor, if you set it for status out of an abundance of caution, I understand. But my understanding is the state had, I guess, e-filed that which the client had already executed.
It had all the signatures on it, yes.
It was put in the queue late on Friday afternoon, so it's signed now.
Thank you, Judge. The last matter that Mr. Dyram has under his name is, I think it's Ryberg, R-Y-B-E-R-G, first name Richard. And it's my understanding that Mr. Snell and Mr. Dyram agree it's a PTI, that the paperwork has not been completed. We're suggesting 5/12 to allow the PTI paperwork to be completed and filed, Your Honor.
The state would agree with that.
All right, PTI status on 5/12.
Thank you. Judge, under my name, the first matter is Gene Ward, W-A-R-D. Judge, I received, well, there were two cases. One has been disposed of already, if I'm not mistaken. We're about to be. But the other has not been, and the state sent a proposal to me. We're asking to continue this matter, and I think the state does not object to that assessment.
That's correct.
All right, matter will be continued.
Thank you. Next matter is Kenneth Starr. Judge, may we approach on that? I think that might be wise, if that's okay.
Yes, sir. Star.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Judge, the final matter that I have, Mr. Marquise Dewberry, and he is present, Your Honor. Judge, this is a case I had with Mr. Gomez. You know, I'm well aware of the admonition the court gave with respect to a plea. My question is this. If there is another occasion this week on the court's docket that we might do that, Mr. Dewberry, and I met with he and his family, they just need more time to talk to me about, Judge, it's a serious matter. If there's another occasion this week that we might appear before the court for that purpose, I would request that we be able to do that. Is that right, Mr. Dewberry?
I've got Thursday afternoon. I've got pretrial detentions and felony arraignments on Thursday afternoon, so if you believe that you'll have it tied up.
Yes, sir. We'll make every effort and believe that to be the case.
All right.
AJ, you're on.
Because we did announce plea or trial, so.
We did, Judge, and Judge, we're all well aware, and Mr. Dewberry is too. He was present.
Okay, so plea then on 2/20, or we'll see you on Friday morning for jury review.
Very well, Your Honor. We'll see you Thursday afternoon
Okay.
based on, that's my understanding. Would that be 1:30, Your Honor?
Let's Yes, let's do that at 1:30, which
Yes,
is
sir.
when our arraignments are.
Thank you, Your Honor. And that's all I have. Thank you, sir.
All right, thank you. Mr. Flowers?
Yes.
You got no room down there.
I'm sorry. And I apologize.
No, we did that.
I thought,
Up here.
oh, I know, it's Kenneth Starr, but Starr, we've had, that's been continued to 5/12 is my understanding. Thank you thank you. I appreciate that. Thank you very much.
All right, thank you now. Mr. Durrell?
Morning, Your Honor.
Good morning, Mr. Durrell.
May it please the court, Dustin Durrell. Your Honor, my first client today is Madison Workman. Your Honor, Ms. Workman had a doctor's appointment this morning to make sure she could get her prescription refilled. If we could have a date later this week, I believe we do have a plea ready in this matter, Your Honor.
All right, do you want to come on arraignment day?
That would be great. If I can be here with Mr. Flowers, that'd be fantastic.
All right, plea on 2/20 at 1:30. Now, I should have asked, is that sufficient for you to put it on the docket thing? Okay, so you need to send a notice.
A notice? Yes, Your
Right.
Honor.
And if you see Mr. Flowers out there, let him know that too.
Yes, Your Honor.
Okay.
And last, Your Honor, I don't know if they've fallen off the docket yet or not. Mr. Tyler Young, the state, I believe, did file an all-cross this past Friday. Restitution's been paid.
So it's been no prost?
Yes, Your Honor.
All right, very good.
All right. Thank you very much. I believe that's all I have.
All right, thank you now.
Thank you.
Mr. Powell? Samantha Jo Lucas, right?
Case number 23 CF 2139. And this is on our motion to withdraw, Judge.
All right.
And she's consented. She signed a written consent. We took this case from a friend. The facts are not as we were led to believe. We've taken all the depositions. There's been no attorney fees paid. None are requested. She's agreed to pay the cost. The state's made a good offer, and they agreed to keep it open for the next court date anyway.
All right.
And we'd like
And what is the present offer from the state?
Yes, Your Honor, we had offered, I just want to make sure I was pulling up the plea offer sheet. We had offered an incarcerative sentence as the defendant does for 15.68 months in Department of Corrections. We also offered, if she wanted to avoid that offer, we offered the entry into the drug court program as an alternative. So she has two choices. Those are the offers that were presented, Your Honor.
All right.
And we recommended she accept it.
All right. Is it your intention to carry forward without an attorney, or are you going to seek an attorney to help you resolve the case at this point, ma'am?
Yes, I plan on getting another attorney.
All right. You able to afford one on your own, or are you going to seek the appointment of? You can afford one on your own? Okay. All right. So, have you spoken to anyone yet?
No, well, yes, I spoke on the phone one time with somebody, but I just have to recontact them and see. I have a couple options that I'm looking at.
Okay. Because the reason I mention that is our next full court date is all the way into May. And I don't really want to set this off that far for you to get counsel and have the case waiting that long, because it has been pending for a while. So what I'm going to do is as I'm going to set it for 4/17, and I realize that's a full docket, but you need to be back on the 17th with your lawyer and those arrangements made for status, and if at that time you're prepared to accept the plea, then we can do that. But I just don't want to extend the court date all the way into the next cycle and without a resolution because of the age of the case. Okay, so we'll see you on 4/17. And Madam Clerk, in addition to that, we'll go ahead and set it for the full, we'll set it 4/17 for status, and we'll reset the whole case for the next trial cycle, just to be sure we don't miss it, okay?
Okay.
All right? All right, any questions?
And I'll send you the order, Judge.
All right, yes. And if you'd ask her, please, to fill out one of those information sheets with updating her address and all her contact information and pass it back to the clerk before she leaves. That way we'll be certain to have good contact information for her to send out the appropriate notices since she's now without counsel.
Thank you, Judge. That's all I have.
Thank you. Good day. All right, Mr. Cobb.
Good morning, Judge. Roderick Bryant. Are we ready to do inmates? We're going to call non.
Well, if we can, it's up to security. If they've got them queued up, then let's roll.
Judges of the State of Florida versus Roderick Bryant and 2022 CF 2925. I'd like to approach with Ms. Sanders, if that's all right.
Yes.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Backroom Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, The sweet aroma of the Crestview Coney Island
Absolutely.
burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Island's burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at...
All right, very good. Then it'll be continued one cycle, and if you need to set it sooner, let me know.
Yeah, I'll advance it on the docket immediately if I get back from the state, Judge.
Okay, very good. Thank you now. Thank you, Mr. Bryant.
Judge, this is the state of Florida versus Eric McQueen. I've spoken to the state, and we're asking if we can place this on the docket Thursday for a change of plea. Mr. Gomez needs to get up with the victim and clear the plea, deal with the victim and talk to her about it. We don't want to just plead it out today without having gone through the victim first. I don't know if the court has time on the docket to do that, but that's what we'd like to do.
So you want to make a plea on Thursday?
Yes, or a change of plea on Thursday.
State?
Your Honor, there's no objection to this. We're wanting to set it on Thursday just because we're trying to, if we can get a resolution, achieve that on Thursday. I just got this counter offer from the defense, and so I want to make sure I can speak with the victim, and if we can wrap it up Thursday, then we will. If not, then we'll have to continue it to the next cycle, Your Honor.
All right, well, we're going to go ahead and continue it to the next cycle and set it for the plea on Thursday. I mean, once again, I'm just trying to touch it only once, because if we get to Thursday and there's no plea, then I don't want to forget to set it on the next docket. So,
Yes, Your Honor.
now, you'll need to send a notice up to set it for the plea on Thursday, because that is an arraignment day, and so it's not going to be automatically populated. So send a notice of change of plea for Thursday, okay?
All right, I'm marking that on the docket. I'll do the notice.
Okay.
It's Thursday afternoon, correct, Your Honor?
1:30, yes, sir.
All right, thank you,
And send a
Judge.
copy of that notice to Ms. Natali, please.
Yes, sir. Is Dana Nelson in there? Judge, this is State of Florida versus Dana Nelson in 2023 CF 1941. I filed a motion to withdraw, asking the court to appoint her new conflict-free counsel.
Just give me just a second. When I reviewed, I did not see that, so.
Yeah, I filed it yesterday. I spoke to the bar on.
Well, you don't need to get into those
Okay,
details.
yes.
I just didn't see it when I reviewed did my homework for the docket, so. It is still not on the docket. Do you see it, Madam Clerk? Do you have a copy for the court?
Not a hard copy, Judge. I don't have a hard copy with me.
All right. Well, you filed it, and you're telling me that it's based upon that you believe it's necessary based upon your obligations to the, and your consult with the bar?
Yes, sir.
Okay. And so that's granted. I'll appoint Mr. Nopes at this time.
I'll send over an order, Judge.
Yes. And what I'm going to do is I'm going to set this for status on 4/17. and continue the case to 5/12. That way, Mr. Nopes will have that's the next available court date that we have, and Mr. Nopes will then have it for, to be able to speak to his client. And of course, he'll get this order as soon as you send it in.
Yes, sir, Judge. Thank you.
All right, thank you.
Your Honor, have a great day. Oh, I got some mail coming through, sir. It should be hand delivered.
Judge, the next case I have is Mr. Purnell. Last week I informed the court I was in the process of running a conflicts check. Based on me representing another client and some things that occurred in that case, I feel that there was a need to file a motion to withdraw. So I did file that yesterday to withdraw from the case. I was just recently appointed to this case, I believe, a couple weeks ago. And so there's no prejudice no prejudice will occur to the defendant if we put a new attorney on that doesn't have the conflict. So I'd ask the court grant my motion to withdraw.
Would it be Mr. Nopes, Madam Clerk? Okay. All right, motion withdraw is granted. Nopes is appointed. And we'll do the same thing. We'll set this for status on 4/17 and continue the case to 5/12.
Okay. Thank you, Judge. Judge, I want to go ahead and get my inmates done, if that's all right.
Yes, sir.
The next inmate I have would be Antonio Swain. Just give me 1 second for him. This is, get that one done. All right, Judge, I thought I was going to be able to take care of the battery on a jail detainee, but we're going to try to resolve all these cases together. This is the State of Florida versus Antonio Swain, 2022 CF 1589, 2024 CF 179. The state and I have been in negotiations. I made an offer, the state made a counteroffer. If you remember last week at pretrial, we discussed the issue with regards to testing the fentanyl. So I believe the state's going to want to test all the pills to come back with a weight that reflects every pill being tested. So we're going to be asking for a continuance in this case. I was hoping we'd be able to get it resolved, but it looks like we're not going to be able to. But if Mr. Snell and I come up with something in between now and the next court date, I will advance it on the docket. But that's where we are right now, Judge.
Okay. All right, so that's it. No more. Last continuance.
So if they don't get the drugs tested back, they don't have any more time to get the drugs tested.
As one of the old-timer judges, I've been around long enough. You remember when they were having all the alien sightings over in Gulf Breeze?
Yes, sir.
I just remember a judge up there in Milton said about another continuance, said, unless there's an alien abduction, we're not having another continuance. So you understand what I'm saying? there would have to be a super extraordinary circumstance for this case to be continued again.
It's completely understood.
Okay? Understand?
Yes, sir.
Okay.
All right, thank you, Judge.
All right.
Lori Wycheck. Judge, this is the state of Florida versus Lori Wycheck, case number 2023 CF 2268. We'd entered a plea last week, and then there were some issues that came up concerning the parameters of the plea and what Freedom House would do and what Freedom House wouldn't do.
Correct.
And I've spoken,
And I said to let's hold on, bring her back, be sure, because I want her to have the support she needs to be successful. I don't want there to be any issue with that. But at the same time, I got to be certain that the department and the state are on board that that's going to be an appropriate placement.
Yes, sir.
Is that focus with your memory?
Exactly
Okay.
what it was about, yes, sir. And I've spoken to Mr. Snell. We're ready to leave the plea intact as it was entered. At the pretrial, we do understand now the parameters of what the Freedom House does and what they do. They will make referrals for her to undergo a psychological evaluation at Bridgeway and a substance abuse evaluation at Bridgeway. And then they will even transport her to and from those locations to help her get the help that she needs. And I spoke to Freedom House, and they've had people or defendants in their program that are on community control. So they're familiar with working with the Department of Corrections, a community control officer, with regards to status updates and stuff like that. So I think we're all comfortable now. I believe we are with leaving the plea intact and moving forward.
Yes, that's correct. I actually got a chance to speak with them.
Okay, so really, we're here back on a status, the plea remains outstanding, and now she can go and take her bed at Freedom House as soon as it's available.
Yes, sir.
Okay? All right, so with that, though, once she's released, she's still going to need to initially report to probation or make arrangements with Freedom House to make that reporting take place since she's going to Freedom House, right?
Yeah, I instructed Freedom House. It would be from jail to bed. Freedom House will pick her up, and then they will arrange for her to meet with the community control officer.
Okay. Okay?
You know, we spoke with, when we thought all this was going to happen last week, we did speak with Freedom House, so they just need to be reminded that they have to come to our office first, and then we will transfer to Walton County, because they are in Walton County.
All right, so that's all squared away, so we got that. And I'm sorry for the delay, but as I said, I wanted to be sure you had the support you needed. The last thing we do is get you over there and then have a hiccup and have some issues. So it's all squared away, so the plea remains outstanding, and you're then to be taken to Freedom House. Okay, thank you now.
Judge, my last inmate I have is Ms. Yepes. And I'd like to approach Mr. Snell if I can.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
This is Yepes in 2024, 432, 2024 CF 2023. I'm going to be asking for a continuance so that I can proceed an alternative type of disposition in the case.
Yes, sir.
Thank you.
It'll be continued to 5/12 based upon our discussion at the bench, and just be sure you collaborate with the state so we move that forward. If you have a resolution before then, you can advance it.
Yes, sir, Judge. Thank you.
All right?
And then I have some out of custodies. Mr. Donald Bruce Sanders. Judge, this is Mr. Sanders, present for the court in 2023 CF 2460. I was appointed in September to represent Mr. Sanders after Mr. Nopes had a conflict of interest. We've done depositions in the case. During the course of the depositions, there was one witness that didn't show up that we need to depose. His name is Trey West. Mr. Snell and I have been back and forth about a possible plea in the case, but right now we're not able to reach an agreement. I am going to be asking for a pass so I can depose Trey West, who is the witness in that case, and I don't believe the state has an objection to a continuance.
No, sir, no objection.
All right. The only reason I'm being pushy here is this is an older case. When are we going to set this deposition?
Well, Mr. Snell and I have depositions scheduled in another case, State versus Rybecki, I believe in April. And there's some time that morning with witnesses that I can squeeze this one witness in.
And that sounds perfect.
All right. So April, what is that date?
Look and see. No, you can't speak to him. I have talked to him. Judge, let me pull that up really quick and I'll find it for you. Okay, that is hold on, Judge, I got lots of emails from his. April 23rd.
You agree, Mr. Snell?
April 23rd, yes, sir.
All right. So Mr. West will be set on April 23rd. And with that, the matter will be continued to 5/12. And based upon the age of the case, we would anticipate the disposition or a trial that cycle.
Yes, sir. That's it. Okay, thank you. All right, the last case I have is Star Lynn Saylor, State versus Saylor, 2024 CF 2589, 2024 CF 2600. when Mr. Stone and I had talked about the possession of a controlled substance case, I thought that the case was going to be null pros because what the labs came back as for wasn't included as a controlled substance, but we both realize now it is actually a controlled substance. So we're not prepared to dispose of the case today. I was appointed January 3rd to represent Mr. Saylor in these cases. And whereas I wasn't going to take depositions in the possession of controlled substance case, now I'm going to, and I'm going to schedule depositions in the fleeing and eluding case. I thought we were going to be able to resolve these cases, and that's the reason depots had not been scheduled. But it is a newer case for me, and I'd ask the court for a continuance so I can get these depositions scheduled.
State?
No objection.
And who specifically do you need to take?
Oh, I'll be taking the depositions of everybody on the state's discovery exhibit, Judge. We've been trying to work it out, but we can't come to an agreement that makes everybody happy. So it'll just be the standard, let's depose everybody on the state's discovery exhibit.
Okay. All right.
But we've been working the case, trying to get them resolved.
All right. All right, very good. It'll be continued to 5/12.
Thank you, Judge. Judge, those are my cases this morning. Can I be excused?
Yes, sir. Good day.
Thank you, you too.
Mr. Keach, are you ready or you need a minute?
I can be ready, Your Honor.
All right.
I am here in the state of Florida versus Levi Lucas. We left it set for today. I'm looking out into the gallery and I do not see Mr. Lucas present.
And just for the court's awareness, we left it set for today because Mr. Keach had asked for Mr. Lucas to actually have contact with him. And so we're now back in a scenario where there hasn't been any contact and he's not here. So the state's going to be requesting a KP, Your Honor.
And Mr. McKinney, you're standing in for Mr. Kleins, who also represents the defendant in 24 CF 1010.
Yes, sir, I am.
Any illumination you can provide?
No, Your Honor, it's not. Well, I can say that Mr. Lucas' case with Mr. Pines is currently set on the 417 docket for a motion. But as far as contact or anything beyond that, I cannot inform the court anything else.
All right. Issue a no bond capias, Madam Clerk, in 24 CF 1010 and also 22 CF 1918.
Since time is limited on the 417 docket, I'm taking that motion off of the docket.
Yes.
And Judge, that concludes my business. May I be excused?
Yes, sir. Thank you, Mr. Keach.
Thank you.
Good day.
Thank you.
All right. Mr. McKinney or Mr. Koch,
I'm
you.
with Derek Newman.
Newman, please.
Newman is president of the podium. 24 CF 338. I'm standing in for Mr. Kleins. We've reached an agreement in Mr. Newman's case. The agreement is a plea as charged, adjudication of guilt, credit for time served, $515 in court costs, $150 cost of defense. No objections to the score sheet.
And Your Honor, this is a downward departure for the purposes of a legitimate uncoerced plea bargain, Your Honor.
Thank you. You may. Good morning. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, and you can put your hand down. You heard what, and so this is just a CFTS, right?
Correct.
With costs?
Yes, Your Honor.
And how much time do you think your client needs?
6 months, 3 to 6 months.
All right, so you heard what Mr. McKinney said, and you signed the written plea form. How old are you and how far did you go in school?
I'm 52 and I graduated.
All right. You able to read and understand this plea form?
Yes, sir.
And did you do that before you signed it?
Yes, sir.
And is what you read what Mr. McKinney just told me?
Yes, sir.
All right, so you understand you're pleading no contest to this charge and waiving your right to a trial by jury.
Yes, sir.
You'll be adjudicated guilty. Your sentence is time served with your fees and costs that you'll have to pay within 180 days.
Yes, sir.
And as long as you're making payments, if you need a little more time, all you need to do is reach out and ask, and we'll provide you the additional time.
Yes, sir.
All right. All right, the court will find the plea to be freely and voluntarily entered into, and will accept the plea. And if you'll step over this way for your fingerprints.
Good morning, Judge.
Good morning, Mr. Koch.
If I may call, covering for Mr. Scott Clients, Mr. Edward Maldonado, and that's 24 CF 1167. Yes, Your Honor. Thank you. This will be a plea of no contest, Your Honor. In counts 1 and counts 2, be adjudication of guilt, 2 years of standard probation with the $40 per month cost supervision, 24 hours of community service, $615 in court costs, $150 in defense costs. Probation will automatically terminate at the 1-year mark if every condition is met and no violations. Count 3, which is the misdemeanor, Your Honor, adjudication of guilt, credit for time served. Count 4 will be null prost. If I may approach with the signed plea form and no objection to this court.
Granted. 548
Thank you, Madam Clerk.
plus cost of defense. All right, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, and you can put your hand down. You heard what Mr. Koch said on your behalf and signed the written plea form.
Yes, sir.
How old are you and how far did you go in school?
43, and I graduated high school.
All right, you able to read and understand the plea form?
Sir, yes, sir.
And did you do that before you signed it?
Sir, yes, sir.
And does it contain the terms and conditions that were just announced?
Yes, sir.
All right. Do you understand by this plea arrangements you're pleading no contest to the charges?
Yes, sir.
And that says to me that you believe the state has the evidence to prove your guilt and you're not going to contest that.
Yes, sir.
Do you understand by doing this you're waiving your right to a trial by jury where the state would have to prove your guilt beyond a reasonable doubt?
Yes, sir.
All right. And in this case, you'll be adjudicated guilty. You're going to be on 2 years of probation with some fees, costs, and other conditions that were recited in the plea agreement. You can terminate at 1 year if you've met all your conditions and you have no violations.
Yes, sir.
Well, actually, it's an auto termination at 1 year if you have no violation. Has Mr. Koch or Mr. Kleins answered all your questions about the plea and how it affects you?
Yes, sir.
And are you satisfied with how you've been represented?
Yes, sir.
The court will find the plea to be freely and voluntarily entered into. Accept the plea if you'll step over here for your prints, and then probation will have some instructions for you before you leave.
Your Honor. Mr. Klein's next case I'd like to call, Your Honor, Mr. Tyrone Malloy, who's present and approaching in 24 CF 2110, Your Honor. Mr. Malloy.
Good morning.
Your Honor, this will be a change of plea and no contest this morning. It'll be plea as charged, withhold of adjudication, court costs, and then there's $150 in defense costs, Your Honor. If I may approach with the signed plea form and no objection to this score sheet.
You may. All right, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes.
Okay, and you can put your hand down. You heard what Mr. Koch said on your behalf and signed the written plea form?
Yes, sir.
And how old are you and how far did you go in school?
30 years old. Didn't finish.
Okay. Yeah, but you able to read and understand the plea form? And did you do that before you signed it? And is what you read what Mr. Koch just announced to me? All right. And so this is just a plea in cost, is that right?
Correct, Judge.
All right. So you understand that you're pleading no contest to this charge, waiving your right to a trial by jury, and adjudication will be withheld, and you'll have the court cost and cost of defense. And the court cost would be, Madam Clerk? $515 plus your cost of defense, which would be $150. How long do you need to pay those, you think?
At least 90 days.
Say again?
At least 90 days.
Okay.
I'm currently looking for a job right now.
Well, I'll give you 180 days just to be sure, to get that squared away based upon what this is, because you're going to have the other stuff that you need to take care of with DHSMV too. So let's get this in, and as long as you're making payments, if you need a little more time, because the goal here is to get that stuff paid, because you'll need to get this paid to take care of the other stuff, right?
Yes.
All right. So as long as you're making payments, if you need more time, let me know and I'll give you more time. But if you're not making payments, I'll just go ahead and send it to collections, which means that you won't be able to take care of your other driving issues, right? Okay? So, all right. Find the plea to be freely and voluntarily entered into and accept the plea. Thank you.
No fingerprints to withhold?
No.
Okay. Yes, sir. Next on Mr. Klein's list, Your Honor, if I can call Alicia Marshall in 24 CF 2267. Just reviewing my notes, Your Honor. Mr. Klein's did file a waiver, Ms. Berkman?
Yes, Judge, if I may, a waiver has been filed for Ms. Marshall. State had offered a PTI in this case, however, Ms. Marshall has provided proof that she has completed everything that we were going to ask for her to complete within the PTI. So for those reasons, the state would announce a dismissal at this time.
All right. Matters dismissed.
Next for Mr. Klein's cases, Your Honor, if I can call Scott Moose, M-O-O-S, in 24 CF 1886. And I believe Mr. Gomez, sorry.
Is there a Miss Vicki Milligan in the courtroom today? Your Honor, may I get some testimony from her just real quick before we handle this? It'll take a few minutes, or a few seconds.
Yes.
All right, if I can call Miss Milligan, just stay there.
Yes, sir.
You want her at the stand?
Yes,
Hey,
please.
yeah, the stand's fine.
Up here. Yes, ma'am.
You just watch her step, see if got
I'm sure.
No chair, huh?
It's a new meaning
All
of
right, if you
take a
raise your right
stand.
hand, please. Madam Clerk, will you swear the witness?
I do.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right. Please be seated and direct your voice to the microphone you see in front of you. Speak clearly and distinctly. It's important we're able to hear and understand you. Also, there's a court reporter buried in the back of the courthouse taking this all down, so it's important they're able to make a good record, okay?
Yes, sir. Thank you.
Now, if any of these lawyers object, you need to stop speaking immediately until you receive an instruction from me on how to proceed. Is that okay?
Thank you, sir. Yes.
Okay. Mr. Gomez, you may inquire.
Hi, ma'am. Good morning. Can you please state your name for the record?
Yes, my name is Vicki Lee Milligan.
Okay. Ms. Milligan, we're here in this case with the defendant, Mr. Moose. Did you file a drop charge request in this case?
I did.
Okay. Is it your wishes and desires to still have that drop charge request?
Yes, it is.
Okay. You do not want to be involved in the prosecution of this case?
I do not.
Were you forced or coerced or promised anything in exchange for writing that request to drop the charges?
I was not.
Do you understand that if I dismiss this case today, there will be no recourse in the future for this incident?
I do understand.
Okay. I have no further questions, Your Honor.
Do you wish to inquire, Mr. Koch?
No, Judge.
Is the witness released?
From defense, yes.
Thank you very much. You may
Thank you,
step
Judge.
down.
Have a nice day.
You're welcome.
Bye.
Your Honor, at this time, based on the testimony of Ms. Milligan, the state would announce a dismissal of this case against Mr. Moose in 24 CF 1886.
All right. Case is dismissed. Thank you.
You're welcome. Let's see. Judge, if I may call, Mr. Klein has a Christopher Morris in custody. Can we call?
Christopher Morris?
If he's ready.
Doesn't Mr.
Yes.
Doesn't Mr. Nopes have him too? Or am I confusing that with someone else?
Judge?
Oh, no, I'm sorry, Your Honor, that was Ms. Jaquette. I have filed a no pros as of Friday as to Ms. Jaquette's case.
So that's the 24 CF 2501?
Hold on, Your Honor, I'm sorry. Yes, that's correct. And I believe we filed a no pros on Friday that should have came through.
All right.
Judge, this is Mr. Christopher Morris in 24 CF 2824. And if I may have just a brief moment.
Yes, sir.
Your Honor.
You're welcome, sir.
Your Honor, Mr. Morris will be entering a no contest plea this morning as charged. It will be credit for time served. He has $615 as court costs, but I believe this is a $515 court costs, Madam Clerk. Okay, I'm going to make that correction right now, Your Honor. So it was $615. It's going to be $515. And I'm just going to have you initial right by that because I just made a cross out. And of course, there's a $150 PD fee, Your Honor, and this will be an adjudication of guilt. If I may approach with the signed plea form and no objection to the score sheet.
Granted. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, and you can put your hand down. You heard what Mr. Koch said on your behalf and you signed the written plea form?
Yes, sir.
How old are you and how far did you go in school?
53, I got a GED.
All right, you able to read and understand the plea form?
Yes, sir.
Did you do that before you signed it?
Yes, sir.
And is what you read what was just announced?
Yes, sir.
Do you understand as to this charge you're pleading no contest?
Yes, sir.
Which says to me you believe the state could prove your guilt by evidence and you're not going to contest that.
Yes, sir.
And do you understand by making this plea you're waiving your right to a trial by jury where the state would have to prove your guilt?
Yes, sir.
In this case, you'll be adjudicated guilty, credit for time served, and you'll have the announced fees and costs that you'll have to pay. How much time do you need to pay those after your release?
A year, would that be good?
Yes, sir. You'll have a year to pay.
Yes, sir.
And as long as you're making payments, if you need more time, you can ask for it, all right?
Yes, sir.
Because the goal here is to get that stuff paid off. That's
Yes,
my
sir.
goal.
Yes, sir.
And if you need a little more time, you let me know.
I'll get it.
Have all your questions been answered about how the plea affects you?
Yes, sir.
And are you satisfied with how you've been represented?
Yes, sir.
The court will find the plea to be freely and voluntarily entered into, or accept the plea with the adjudication. Thank you.
Excellent. Your Honor, that's all of Mr. Klein's cases. If I may go down my list that's present in the courtroom.
Well, I show Kirsten Mann. Kirsten Mann.
Yes, Your Honor. In two cases, 24 CF 1944, 25 CF 23. If we can call the halls for Miss Mann. Kirsten Mann present.
Judge, I believe it looks like there was contact with Mr. Kleins in this case and negotiation for a plea agreement. If we can just pass it to the end of the docket.
All right.
See if we can find the man.
All right. And then, did we take care of Mosley?
Negative, Judge. Mr. Mosley, if we could also pass that to the end of the docket, Your Honor, for Mr. Mosley.
All right. And then we're going to take a 5-minute comfort break at this time. 5 minutes.
All right.
5 minutes, counting down.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over...
We have reached an agreement for Ms. Thomas. She wishes to withdraw her previously later plea of not guilty and a plea of no contest. The agreement that's been reached with the state is for a lesser included offense in count 1. So the intention would be a plea to 2 counts of possession of paraphernalia. So this would be misdemeanors only, 12 months probation with JCS. I have provided JCS's contact information to Ms. Thomas. She is aware that there's normally a $50 cost of supervision for JCS. Special conditions include a substance abuse evaluation and treatment, random urinalysis, and standard misdemeanor court cost. Madam Clerk, I've written down $270 and a $150 cost of defense. Is that accurate? That would be with an adjudication on the misdemeanors. May I approach that agreement?
Granted. Raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
I do.
All right, you can put your hand down. You heard what Mr. McKinney said, and you signed the written plea form.
Yes.
All right, you understand you're pleading no contest to the, it's now 2 counts of possession of paraphernalia.
I do.
You will be adjudicated guilty. You'll be sentenced to 12 months of probation with JCS with the special conditions of the evaluation and any treatment. You'll have random testing and the court costs which were announced.
Yes, sir.
Mr. McKinney answered all your questions?
Yes.
And you're satisfied with what he's done for you?
Yes, I am.
I'll find the plea to be freely and voluntarily entered into, and I'll accept the plea. Thank you.
Thank you.
See if they need you over there before you're free to go. Okay, good to go. Just call JCS on your way out. Okay? Judge, there was a Troy Tire on the docket in 24 CF 1729. I believe that case was been null prost. Okay. Alfredo Villa. Mr. Villa is present and approaching in the courtroom. He's going to be followed by Cruz Watson. Judge, Mr. Villa is approaching in 24 CF 262. We passed this case over today to see if we can make some headway. The person that we're looking for is Robert McCaslin, who is the listed victim in the case. I've provided the state the investigative efforts from my side of things. So I believe that that is who we are trying to get to see if we're going to move forward with this case or not.
And he's in Tallahassee, right?
That's correct.
Yes, sir. I believe he's not in the local area. I found a number of addresses, but I've provided all that to the state. So at this point, I guess that's the long way to say that we haven't reached where we're at for dismissal today. I would request a continuance, but I recognize the age of the case. That's the linchpin of what's keeping us from moving.
And that's the victim, you say?
Yes, sir.
So what are we going to do with the case at 512 if you still haven't located the victim, their state?
And we would be dismissing the charge due to witness unavailability.
All right, we'll continue the case to 512 with the anticipation that it's either going to be tried.
Yes, sir. If we're still in this position in 512, then that would be the defense perspective, but we're going to continue to work with the state.
All right. All right, very good.
As far as 512 goes, Judge, Mr. Villa does travel over from Panama City. Is there a way that I can waive his appearance for 512?
You can waive his appearance on 512. If it looks like we're having a trial, then I want him back on docket day to review that for the final pass, and then, of course, jury review.
Yes, sir.
Okay.
Thanks.
All right, thank you now.
Yes, sir. Judge, I have Cruz Watson in the courtroom. Mr. Watson is here in 24 CF 2368. Judge, we received the PTI paperwork today, so we would just need a control date for 512, and it should come off the docket in 512.
All right, 512 for PTI status.
only if it's necessary to cover. Okay, good to go. Yes, sir. And Judge, I would like to pass until the end of the docket Mr. Kelvin Watts and Mr. Jerice Williams. I need to write up an agreement for Mr. Williams.
All right.
And that leaves me with Vanessa Williams in the courtroom. Ms. Williams is present and approaching. And as she is, Judge, this is a similar situation where we did receive the PTI paperwork today. We're just going to ask for a control date on 5/12.
Okay, PTI status on 5/12. Thank you now.
You're good to go. I'll turn it over to Mr. Conley.
Your Honor, if I may call Ms. Natasha Powers, who's present and approaching in 24 CF 2259. Yes, Your Honor. Ms. Powers' intention is to enter a no contest plea, Your Honor. But before she wanted to sign the plea form, she wanted an opportunity to discuss possibly waiving that $40 per month cost supervision. I informed her that this court may proceed with that, but if we get some testimony from my client first before she enters this plea.
All right. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury? Okay. Go ahead, Mr. Koch.
Thank you, Judge. Can you just please state your full name for the record? Thank you, Ms. Powers. You understand that this probation offer does have a $40 per month cost supervision? And your discussions that that $40 per month will be a hardship to pay every month? Can you please explain to this court why would that be a hardship?
Well, because I would have to surrender my tag for my car, and I don't have a employment anymore. And also, I'll have to work on trying to get my SR22 since my license will have to be suspended for a year. But I do go to church. I am active in the church. I go to church on Sundays, Wednesdays, Fridays, and Sundays. So, I just will not have the means, considering the fact that I had to put in my 2 weeks because I won't have a means for transportation to work.
And just because part of this plea deal is, and you understand your license will be revoked for a year.
Correct, but I will still be able to get my SI-22s, correct? Hardships?
That, as we talked about, let's address that in a second. Let's just stick with this $40 per month. Is there anything else you want this court to know so the judge can understand that this is going to be a hardship for you, $40 per month?
No.
Okay. Thank you, Your Honor. And just because my client did bring up a term of this plea, if I may, my client's license will be revoked for 365 days for the fleeing and looting, Your Honor. I made it clear that this court does not control the DMV. They make their own rules. It's my understanding, though, that it's a hard suspension for that full year. But I did tell her that this court has no objection for a hardship license if and when she qualifies. If I just may put that on the record, Your Honor.
Absolutely. And based upon the testimony of her, the court will find there's good cause to waive the cost of supervision under the circumstances.
Thank you, Your Honor. If you want to move forward, please sign there. And today's the 17th. Okay. Thank you. And Your Honor, this will be a no contest plea as charged. It will be adjudication of guilt, 2 years of standard probation, court costs, or excuse me, that now the $40 per month cost supervision is waived. There is $515 in court costs, $150 in defense costs, 24 hours of community service, and the driver's license will be revoked for 365 days. You have a question for me?
So last week.
Can I have a moment, Your Honor?
Yes.
Your Honor, may I speak with Mr. Gomez just briefly? One second. And Your Honor, there is a term I had to handwrite in and my client did initial by it. There is an early automatic termination after 1 year if all conditions are satisfied and no violations. If I may approach with a signed plea form and no objection to the score sheet.
And then the court cost will be 548 plus the DD.
548?
Yes, sir.
Gotcha. 548. All right. The court cost instead of 515 will be 540. That was my apologies on that.
All right, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right, and you can put your hand down. You heard what Mr. Koch said and you signed the written plea form.
Yes, sir.
How old are you and how far did you go in school?
I'm 32. I'm 31, I'm sorry. And I completed high school and I have my associates.
All right. Are you able to read and understand the plea form?
Yes, sir.
Did you do that before you signed it?
Yes, sir.
And it's what Mr. Koch just announced to what you read in the plea form. You understand by making this plea, you're pleading no contest in this case.
Yes, sir.
And that says to me you believe the state could prove your guilt and you're not going to contest that.
Yes, sir.
In this case, do you understand you're waiving the right to a trial by jury where the state would have to prove that?
Yes, sir.
You're going to be adjudicated guilty, be on 2 years of probation with the fees and costs. And the 24 hours community service, your license will be revoked for the 365 days. You have an automatic termination after a year if you have no violation and all your conditions are satisfied. And the court has no objection to any permit as soon as you're qualified to do that. Mr. Koch answered all your questions about the plea and how it affects you.
Yes, sir.
You're satisfied with how he's represented you?
Yes, sir.
The court will find the plea to be freely and voluntarily entered into and will accept the plea. Thank you.
Next, I can call Mr. Terry Price, who's present and approaching in 24 CF 1926, Your Honor.
Good morning.
Good morning. Yes, Your Honor. Mr. Price was appointed to me on pretrial on March 10th. He's already came to my office with an appointment, so we've had time to discuss the 24 CF 1926 case. I just also want to point out my client was appointed to me on Thursday, the 13th, in 25 CF 254, Your Honor, on a separate charge. I'm seeking a one-cycle continuance and to keep both these cases together.
State.
State has no objection, Your Honor.
And Madam Clerk, if you'd have those cases travel together, have we been, and we had arraignment on that 5-4 case, right? And so we're ready to put that on 512, is that right?
That is correct, Judge.
Okay. All right, so they'll travel together. We'll see you. Stay in touch, and we'll see you then. All right, thank you now.
Yes, that's our next court date. Yep. Yes, sir. Next, if I call Mr. Hayward, last name Reeves, who's present and approaching in 24 CF 847.
So I showed that one as continued. Do we?
Mr. Hayward Reeves.
Reeves?
There is a Matthew Reeves that I had with Mr. Flowers that got continued.
Okay.
And this is 24 CF 847.
Okay, go ahead.
Yes, Your Honor. I believe the state has an announcement for this matter.
Judge, this time, the state would dismiss the charge in 24 CF 847. We have witness unavailability issues in that case.
All right, case is dismissed.
Yep. Yes, sir. Judge, if I may call Mr. Kelvin Robertson, who's present and approaching, and that's 24 CF 1385, Kelvin Robertson. Yes, Your Honor. This will be a plea of no contest. Count 1 is going to be the lesser included offense of simple assault, second-degree misdemeanor. That's Florida Statute 784.011. This will be adjudication of guilt, credit for time served, court costs, and 150 in defense costs, Your Honor. If I may approach the signed plea form, and this is a misdemeanor, so no sanction.
Granted. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right. And Madam Clerk, you can put your hand out. Proper fees and costs, Madam Clerk.
622 plus the
You heard what Mr. Koch said on your behalf, and you signed the written plea form?
Yes, sir.
Do you understand that you're pleading no contest to the lesser included offense?
Yes, sir.
Waiving your right to a trial by jury? Do you understand that? And that you're going to be adjudicated guilty of that offense and sentenced to time served with the fees and costs that were announced?
Yes, sir.
How much time do you need to get those paid?
Like 180 days.
Okay. All right, Mr. Koch answered all your questions about the plea and how it affects you,
Yes, sir.
and you satisfied with how he's represented you.
Yes, sir.
I'll find the plea to be freely and voluntarily entered into and accept the plea.
Just get the fingerprint. Yes, sir. Judge, next if I can call Mr. Miguel Rodriguez, who's present and approaching in 24 CF 2378.
Good morning.
Good morning.
Your Honor, this will be a change of plea of no contest this morning. Count 1 is going to be the lesser included offense of possession of drug paraphernalia, a first-degree misdemeanor. That's Florida Statute 893.147, subsection 1. Terms of the plea will be a withhold of adjudication, 12 months of probation, which will be supervised by JCS, $50 per month cost supervision. There's court costs, $150 in defense costs, substance abuse evaluation with any recommended treatment, and 24 hours of community service. Probation will automatically terminate at 6 months if all conditions are satisfied and there are no violations. If I may approach with the signed plea form.
Granted. Is that the state's agreement?
Yes, sir.
Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
I do.
All right, you can put your hand down. You heard what Mr. Koch said on your behalf and signed the written plea form?
Yes, sir.
Do you understand by this plea arrangement that you're pleading no contest to the lesser included charge and waiving your right to a trial?
Yes, sir.
Your adjudication will be withheld. You'll be on 12 months of probation with the fees and costs that, what are proper fees and costs, Madam Clerk?
270 plus the
And you'll be on a 12 months of probation with JCS, with your cost supervision, evaluation and treatment, and your 24 hours of community service. You can automatically terminate at 6 months if you've done everything and you have no violations. Is that your agreement?
Yes.
And Mr. Koch answered all your questions, and you're satisfied with how you've been represented?
Yes, sir.
Court will find the plea to be freely and voluntarily entered into and will accept the plea. Thank you.
Thank you.
And this is GCS. You're going to check in today, but call first, but head over today and check in today.
Okay, and I can tell them about switching me over to...
Yep, but definitely check in today.
All right.
Do you accept it? Okay.
Judge, may we recall Levi Lucas?
Lucas, please.
Mr. Lucas, President approaching in 24 CF 1010. He was not in the courtroom when we called him earlier. He's represented by Mr. Kleins and Mr. Keach.
Right.
And I messaged Mr. Keach, Your Honor. Can I just read what he responded back with as a recommendation?
Yes.
He just recommended that the court set up for the next pretrial, stating that there are no more continuances to be granted and a final or a discovery cutoff date of April 1st for the defendant to provide any reciprocal discovery, Your Honor. And I know Mr. Keach was speaking, I would just ask this court to impress upon the defendant that he needs to get up with Mr. Keach in that case, or else he's not going to be able to adequately defend him.
All right. I withdraw the capias.
Thank you, Your Honor.
Thank you, Judge. And Madam Clerk, on Mr. Kleins 24 CF 1010, he did have the motion hearing scheduled on 417.
So we'll leave that on for 417. Yes, sir. You got to stay in touch with your lawyers.
Yes, sir.
You have part of your conditions of your pretrial release is to cooperate in the resolution of the case.
Yes, sir.
And it's not just showing up in court, but it's cooperating to move the case forward. So if you don't meet with your lawyers, if you don't cooperate with them to move the case forward, then that's also a basis to have your bond revoked, okay?
Yes,
not
sir.
just failing to show up in court, you understand?
Yes, sir.
Okay, all right. So you need to get in touch with Mr. Kleins and also in touch with Mr. Keach. You need to be here on the 17th and then be back on 5/12. But in the meantime, follow their instructions and meet with them, okay?
Yes, sir.
All right, thank you now.
And for the record, I did provide Mr. Keach's phone number to Mr. Lucas.
Okay, thank you now. Good day.
Judge, if I may call Mr. Brandon Rogers in 24 CF 1525. Mr. Rogers is present and approaching, Your Honor.
Yes, sir.
Your Honor, Mr. Rogers was set today, docket day, plea or continuance. We had a counteroffer. Mr. Snell did reach out to the alleged victims in this matter. That was turned down, unfortunately. I'm seeking a one-cycle continuance and understanding that this case will be either trial or plea next cycle on 5/12, Your Honor.
State.
No objection.
All right. So we'll continue it to 5/12. After that, it's on that cycle, it's a plea or it's a trial.
Yes, Your Honor.
Okay. All right. Thank you. Stay in touch with your lawyer. Good day.
Yep. Judge, next, if I could call Ms. Carrie Rudisale in 24 CF 1775, who is present and approaching, Your Honor.
Good morning.
Your Honor, this was set for plea or trial. My client wants to move forward with trial, Your Honor.
All right. And so what is the state's current offer?
Plea to misdemeanor petty theft, Your Honor.
If I may list the terms also, Your Honor.
All right.
Mr. Snell's correct. This would be a lesser included offense of petty theft, the first-degree misdemeanor. The adjudication of guilt, 12 months of probation to be supervised by JCS, $50 per month cost supervision. There was the court cost, $150 defense cost, Total amount is $600 in restitution to the alleged victims, with a minimum of $50 per month towards that restitution, and then no contact with the alleged victims, 24 hours of community service, and an anti-theft course, Your Honor.
All right. And so your client understands that after today, there will be no plea, no agreed upon plea. It would only be a plea as charged, right? And right now, she's charged with grand theft, larceny over $750 but less than $5,000, which is a third-degree felony, and it carries a maximum potential sentence of 60 months in state prison. What does her score sheet show?
It's going to take me a minute to log in, Your Honor. If you'll give me a second.
Mr. Koch, have you seen the score sheet yet?
Judge, negative. The fact it was a lower misdemeanor, Mr. Snell did not present anyone with the score sheet, Your Honor. Your Honor, while Mr. Snell's looking up the score sheet, may I also offer some more information on the record for today?
Yes.
Going over trial, my client did provide a witness, Mr. David Rutherford. I did e-file that witness list this morning, and I emailed a copy to Mr. Snell, including Mr. David Rutherford's name and address. So I just want to notate that on the record, Your Honor.
So David Rutherford is a potential witness?
Correct, Judge. Defense witness, Your Honor. Yes.
I didn't realize that until just now, so I don't know anything about that. I was advised earlier that someone had come to court with the defendant that apparently was there, which I've never heard that this person was there. So it's new information, Your Honor. I haven't had a chance to talk to the person or anything like that either.
All right. Have you spoken to this potential witness, Mr. Koch?
Yes, Judge, this morning I have, Your Honor. And I also told my client I already scheduled her for this Wednesday for an office appointment also, just to gear up and be ready for a trial review day on Friday. But I spoke with Mr. David Rutherford this morning.
All right. All right. And why is it that we're just now finding about this witness? I'm not good with math, but let's see. August, September, October, November, December, January, February, March. I think that is 8 months after, and if we just be generous, that would be 6 months after the obligation to disclose such a witness. Why are we just finding out about that witness now?
Yes, Your Honor. The office appointments at my office are available, but you have to call ahead, of course, because I'm in court. Unfortunately, I never had that sit down in my office conference with my client. But as today, I conducted all the depositions, I'm ready for trial. It was set here for plea or trial. My client wants trial, and of course, I wish I had an office conference with her, but she had a witness that, for the defense, is going to exonerate my client. So I filed that witness list, and I emailed a copy to Mr. Smith.
Right. Well, if the witness is made available to the state before jury review, then all good and fine. And if not, then we're going to go to trial without the witness for the failure of the defendant to disclose that witness timely after the case has been pending for 8 months.
Judge, could I follow up with that order from the court?
Yes.
I already scheduled my client and Mr. Rutherford to be present in my office 9:30 this Wednesday.
State has to have the availability to discuss that because the state has to interview the witness, right? Because if you're saying that that's exculpatory, the state has to have the opportunity. But the fact that the defendant chose to withhold this information to the very eve of trial is on the defense, not the state. State's got to have the opportunity to speak to that witness, or you're going to trial without them.
Yes, Your Honor.
Because that's on the defense.
Yes, Your Honor.
All right? So you'll make the witness, Mr. Snell, you're aware the witness will be in Mr. Koch's office on Wednesday. You available to take the witness's statement? Mr. Snell?
Yes, sir. Today is, so we're talking the 19th?
Correct.
Is 9:30?
Yes, sir.
Okay. Yes, sir. I'm available.
And your client understands that after today, there's no plea other than guilty as charged to felony theft.
Yes, sir.
Okay. All right. So we'll see you on jury review on Friday.
Yes, ma'am. So court's Friday, 9 o'clock, but I'll see you Wednesday, 9:30 in my office. Yes. All right. Yes, ma'am. You're welcome. Certainly. Judge, next, if I may call Mr. Anthony Scott in 24 CF 1298.
Just a second.
Yes, Your Honor. This is Mr. Anthony Scott.
All right.
Judge, I'm seeking, well, the state has offered a 6-month DPA agreement this morning. I'm seeking to set this for status on that 512, but to move forward with that DPA, but understanding that if not, this will be a trial next time.
He's saying he hasn't decided what he wants to do on the case. Is that what you're asking for? Objection to that, then. Okay.
So DPA status on 512?
Yes, sir. I believe we can get this to come off the docket pretty quick.
Okay. All right, very good.
Mr. Anthony, you good? Next, Your Honor, present in the courtroom, if I can call Mr. Treek Simpson in 24 CF 1751. He's present in the pro chamber. This is Mr. Simpson, Your Honor.
Good morning, sir.
Good morning.
Yes, Your Honor. This will be a plea of no contest this morning. This will be as charged, all counts, withhold of adjudication. There's 36 months of standard probation with the $40 per month cost of supervision, $515 in court costs, $150 defense costs, restitution to the 5-star beach properties, and that total amount is $13,601.52. And I did put Ms. Tracy Adams as the Director of Finance on the plea form for that restitution. There will be a minimum of $150 per month towards that restitution. Letter of apology to Ms. Tracy Adams. There's 24 hours of community service and an anti-theft class. Probation will automatically terminate at 24 months if all conditions are satisfied and there are no violations. All counts to run concurrent, Your Honor. And I am going to ask Your Honor, if possible, to waive the $40 per month cost supervision due to the amount of the restitution. If I may approach with the signed plea form. Sure. It's 36 months with an option to auto terminate at 24.
Mr. Mayor?
All good? Your Honor, if I may approach with the sign.
You may.
Mr. Snell will provide a score sheet.
If you'd raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, and you can put your hand down. You heard what Mr. Koch said, and you signed the written plea form.
Yes, sir.
How old are you, and how far did you go in school?
26, college graduate.
All right, you able to read and understand the plea form?
Yes, sir.
Did you do that before you signed it?
Thoroughly, yes, sir.
And is what you read in the form what Mr. Koch just announced on your behalf?
Yes, sir.
Do you understand by this plea that you're pleading no contest to these charges?
Yes, sir.
And by pleading no contest, what I understand you to say is you believe the state could prove your guilt by evidence and you're not going to contest that.
Yes, sir.
Do you understand by making this plea that you're waiving your right to a trial by jury where the state would have to prove your guilt?
Yes, sir.
In this case, adjudication will be withheld. You're going to be on 36 months of probation with the cost of supervision, the court costs, and the cost of defense, the restitution, the letter of apology, and the community service, plus the anti-theft class. And the probation will terminate at 24 months if you satisfy all conditions and there are no violations.
Yes, sir.
Now, considering the amount of the restitution, the court's concerned that we haven't established a payment and a start time for that payment. So what's the plan on that? I guess this is my concern, having done this a lot. If we just say, oh, it's $13,601.52 and we don't have a plan, then at 90 days before his termination, they're going to send me a violation report saying he hadn't paid the restitution. And so you see what I'm saying? If we don't set a plan for what needs to be paid and when, then we're just setting him up for failure. That's my concern. So what's the plan? You want to talk to him?
Judge, I believe in the plea form, we have $150 per month towards that restitution minimum.
Which is not going to pay it off.
Correct. Speaking with my client and the work he does, it's kind of feast or famine. He's intending to pay it all off to take advantage of that early auto term. Understanding that he's going to pay the minimum $150 per month, but he does have that carried out there for the early term at 24 if all is paid off. That's the current plan, Your Honor.
When is the first payment due?
I guess a month from today, Judge, 30 days.
All right, so we just say, let's say it's due on 5/1. That's probably the better way to do that.
Yes, Judge.
I'll waive the cost of supervision so long as restitution is being paid. My goal is that all his resources should be directed towards paying the restitution, and if that gives him the opportunity based upon what you said about the income to do so. So you understand?
Yes, sir.
If you're not paying your restitution, then they're going to begin accruing the cost of supervision.
Gotcha.
All right, the goal is to make the restitution payment. All right. With that, has Mr. Koch answered all your questions about the plea and how it affects you?
Yes, sir.
All right. And you heard that discussion, right? The 150 is not going to take care of business. At the end of towards the end of your supervision, 90 days before you terminate, they're going to send me a report that says You're in violation status for not making your payment, and you're going to face a warrant for your arrest for not making your payments. So if that's not taken care of, or if you don't come in here and ask for some change, that's what's going to happen.
Got you.
I like people to know what they're facing so that there's no question about what's going to happen. You understand?
Completely understand, sir.
Okay. All right. With that, I'll find the plea to be freely and voluntarily entered into, and I'll accept the plea. Thank you.
Thank you. Thank you, sir.
You're welcome. Next case judge will be Mr. Roger Smith in 24 CF 1742. Mr. Roger Smith.
Roger Smith, please.
And I did follow waiver in this case, Your Honor, and I believe Mr. Snell has an announcement for Mr. Roger Smith.
That's correct. Judge, this is a situation where we have witness unavailability. We would announce a dismissal in 24 CF 1742 at this time.
Case is dismissed.
Next judge, if I may call Ms. Chantel Smith Holman. She might have just stepped out. I don't know. She's outside, Your Honor. If we could redress that, ultimately the state will announce a no cross in this matter, but I just saw her this morning.
All right. Let's get to Mr. Nopes.
Yes, Judge.
I got one out of custody, she's not here. Okay. Judge, I've got Harley Payson, 24 CF 2051. Judge, she's at the hospital. She says that if we could approach.
For victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
The next case I have is Mr. Gamble.
Hi, I'm Michael
Judge,
Gilbert.
what is the continuous date?
5/12, Mr. Nopes.
5/12. Judge, we've been trying to get deposition scheduled on this 22-2532. We had them set for March 6th of this year, and there was 1, 2, 3, 4 lab techs that did not appear for the Zoom depositions. There was a problem in that well, some of them were DEA agents, but something about a TUI request, and so we communicated back, and then we sent them something. They were not available that day, but I think they decided that now we can reschedule them. The other, so So in regards to that, we do have a date to take the depots, which is this coming Thursday. But Judge, there's no way, that was agreed upon on Friday. There's no way that we're going to be able to get subpoenas out and served to make those happen. The other problem we got is...
And they won't voluntarily appear if they agreed to reschedule?
I went ahead and emailed all of the individuals when I heard about this issue this morning, Your Honor. I've heard back from Trina Doe. She is going to be available on 3/20. I'm waiting to hear back from Parker Bioper, Carmen Salmon, and Courtney Cecil, Your Honor.
And Judge, I'll just, so the record's clear, one of the other problems is that the 4 DEA, et cetera, we got their subpoenas back from the last go-around, and there's 3 of those that have the Miami address. We were using a Pensacola address that we had received, and there's another one that has a California address. I think the state needs to be aware that they probably need to update their discovery with those correct addresses.
Yes, Your Honor, we provided the correct address. We provided the addresses that were listed on the DEA lab report. And so in my email on those 4 lab analysts, I asked for their correct subpoena addresses for any future subpoenas that we would have to send out, Your Honor.
All right, so are you going to be able to be there on I keep saying 3/20, on 3/20, Mr. Nopes, for the depositions if they appear?
So what time are we doing? I think it's through my book. I didn't bring my book in with me.
I'm assuming, based on the email chain that I saw that the 3/20 date was agreed upon by all the parties, so.
When is jury trial review?
Friday morning.
Okay. I should be able to make that. I've got an 8:30 appointment, but I'll be here.
Okay.
And just because I think we need to try to have an idea of where we're going with this, is it the defense's intention that if those depots don't occur on the DEA agents to ask for another continuance?
Well, so oddly enough, Mr. Gomez, you made a comment to me that, these names had been provided the entire time. Well, that gave me time. I appreciate Mr. Cox taking a little extra time because I got to go back and review every discovery list of witnesses that this case has received, and none of the DEA agents or the FDLE agent was ever listed on any of the discovery.
So I'll speak to that. I will 100% fall on the sword. The lab reports were provided to Mr. Nopes back in 2024, a year ago. He's had them for over a year. I understand, and I have no problem with falling on the sword for my mistakes on that, of them not being listed, but they were listed. There was no request for a deposition until February of 2025. Not a single request. And so now the state is being characterized as, we caused this, and that's why we're in this position. I will fall on my sword all day long and say the second that I noticed that the lab reports or the ASA who had the case before me didn't send out the DEA agents in the event of discovery, all day long. But the simple fact of the matter is, he's had all of those reports with those individuals listed far longer than this and did not request a single deposition until the case was hard set for trial in March. So while I will 100% take responsibility for the fact that the DEA agents weren't listed in the amended discovery, the lab reports had been there and he had downloaded them back in January of 2024. And to be quite frank, I've never seen a big fuss about whether or not the depositions of an analyst could or couldn't happen. Just because for the most part, everything that they're going to testify to is in the report.
Right.
So
you must agree, however, that if the person isn't listed on your discovery exhibit, that the defendant would be fair to assume they're not going to be called as a witness, wouldn't they?
No, I have no problem with that. And in the past, Your Honor,
and wouldn't it be also fair to assume that if they're not listed as a witness, that their report's not coming in either?
It could be, Your Honor. I'm just saying in the past, anytime this has happened, I've had a defense attorney reach out and be like, hey, we got this report. Are you going to list the analyst? We want to depose them. That's generally been how that's happened. So I'm only stating that to say I 100%, I've never had a problem falling on the sword and owning up to my mistakes in this situation. I'm also I want to make it very clear there was never a request for any depositions of any law enforcement officers. I'm not talking about just the DEA agents. I'm talking about all of law enforcement officers either at any point until this case was hard set. And he did have all of those individuals the second that he got on the case and got sent all the discovery. My issue is just characterizing with this discovery or this continuance or any continuance request would only be because of the state. I want to make sure that this entire scenario is adequately represented on the record, because while I understand we didn't technically send the names out, he's had the names, he's had the reports. All that would have been hey, are you going to list these discovery or these experts? We want to depose them. That's all that would have taken. And I understand that's not a responsibility on the defendant, but I'm going to make my argument as best I can. They were provided back in January. He should have known that TUI letters were required for the first depositions that we had for these people. They weren't sent to him. So there's multiple issues on both sides of this as to why those depots weren't effective or effectuated back in this March when we had them all set. Because we did give him ample time and a date for those experts to be deposed.
Judge, if I may, I don't think I received any DEA reports until this past January. That's what I'm showing.
I have on my thing that it was back in January of 2024 that 5 of them were sent he got, and then 1 of them is the only one that was sent in January because we didn't even have that report.
Well, and I know this is the reason this court wishes that we had an evidence server maintained by the clerk, because then I would have absolute accountability for when the things were disclosed and when they were reviewed. Right now, I don't. So, but go ahead, Mr. Knopf.
Well, and just another issue about that is we've still got Courtney Howard, which is here locally, and she didn't show up. And we had deposition scheduled yesterday, and she's one of the officers listed. And he's on, and then one of the officers, Gonzalez judge, he's on maternity leave because his wife had a baby.
And we're not going to be using him.
I don't think he's going to use him, but I don't think we can get around that. I think federal law probably tells us we can't force him to give his deposition if he's on maternity leave.
There's only so much that I can drill on that, but the question is not whether you can force him to give the deposition or not, but whether or not you believe it's necessary for your adequate defense to take his deposition.
Judge, I will tell you that the DEA agents are important to my client. That's why I met with him. I've been meeting with him almost weekly. Mm-hmm. He wants the DEA. He wanted these officers taken. I'm doing what I'm asked to do by my client. Mm-hmm. So he believes it's important. Right.
Well, so we think we'll get the agents on 320.
I'm trying my best, John. I've only got from one of them. There was 4 that were outstanding. I've only heard from one of them that would be okay.
All right, so I'll expect to then see you on jury review, and we'll follow up on what's going on.
That's this Friday, Judge?
Yes.
Okay. Judge, my client is over here dying to say something. And it's your courtroom.
Well, and Mr. Nopes, I always turn this obnoxious noise on to be sure you can counsel him not to talk about the facts of the case.
Yes, sir.
Excuse me, because you've practiced in front of me a long time. I'm really, really critical about being certain that, because that's why you got a lawyer. Speak through your lawyer, because what your lawyer says is different than what you speaking out, right? In which case will we be trying if we're trying the case on next week?
22 CF 2532 is the one I'm showing.
correct? Do you agree, Mr. Gomez?
That's correct, Your Honor.
I don't know when I'll see you, but I'll see you before Friday.
And how long do we expect that it will take to try that case?
I think we said with a jury would be 2 days.
That's correct, Judge.
2 days?
Yes, sir.
Yes, Your Honor. And we had hard set it on the 27th and 28th, so I already sent out subs for that 27th and 28th date, Your Honor.
That is correct, Judge. That's what's on my calendar.
And how many jurors?
I think we said 40.
Okay. All right. Very good.
You're scaring me. You're expecting me to remember what I said last time I was here.
No, I'm making a separate set of notes, because, memory like a steel sieve.
I understand. Thank you.
Does your client still wish to speak, or did you?
No, sir.
Okay, good.
We've discussed it, and I'm going to go to the jail and see you in the next couple of days.
All right. We'll see you on Friday. Mr. Catalini?
Yes, sir. Judge Medical, PTI.
Granted.
Thank you, Judge. It's Mr. Andre Salinas, O-L-I-V-A-S. And there's a plea attached to it as well, sir. Oh, Mr. Gomez, you need to sign it.
Yeah, I need to sign it. Your Honor, I think I need to sign both.
There you go, Mr. Gomez. All right. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, and you can put your hand down. Now, we have a different sort of a disposition today. You've agreed to a pretrial intervention agreement, which has the terms and conditions, and you've already signed that, and you've read over that with your lawyer, and you've agreed to those terms and conditions.
Yes, sir.
Now, one of the conditions is that you will enter into a plea. And that plea is, in the event that you fail to complete the terms and conditions of your trial intervention, you'll be returned here for sentencing. Do you understand that?
Correct. Yes, sir.
All right. So, do you understand this plea is a plea of no contest to the charge of felony battery?
I do.
All right. And by pleading no contest, I understand you to say you believe the state could prove your guilt by evidence and you're not going to contest that. Do you understand by making this plea, you're waiving your right to a trial by jury where the state would have to prove your guilt beyond a reasonable doubt?
Correct.
In this case, this is a plea that says if you fail your PTI, you'll be returned here for sentencing.
Correct.
And there's no agreement regarding your sentence.
Correct.
And I like to use a silly example to emphasize that it's absolutely up to me. So I'm driving to the courthouse and somebody cuts me off and I spill my coffee in my lap and I'm just mad. I could take it out on you and put you in jail for 5 years. Now, it wouldn't be the right thing to do, but it would be legal. Do you understand that?
Yes, right. I do.
Okay. Well, me too. I try not to do those things. But the point is, it would be absolutely up to me when you come back if you fail your PTI. Do you understand that?
Yes, sir, I do.
All right. Now, and of course, the goal is for you to complete your PTI, and if you do that successfully, then the state's going to dismiss this case.
Thank you.
Okay. All right. Now, with that, is Mr. Catalinic answering all your questions about the plea and how it affects you?
Yes, sir.
And are you satisfied with how he's represented you?
Absolutely.
Okay. I'll find the plea to be freely and voluntarily entered into, and I'll accept the plea.
Thank you, Judge.
All right. Now, you need to check in with probation right now on that and be sure everything's squared away, okay?
Judge, just one thing, he had a bond. Could we apply that towards his fines and court costs?
Yes, is the cash bond?
Cash bond, correct. How much did you pay?
Cash bond will be applied towards fees and costs.
Thank you, sir.
Oh, probation needs to sign that.
Yes, sir.
Well, it'll need to be, the officer will need to go over it with them before they sign it. I won't sign it.
Oh, you don't sign it?
No,
Right.
I'll take it with me be.
So what I'll do then is I'll continue this to 5/12, Mr. Catalinic, for PTI status only. And the only reason we do that is that way the paperwork will be sure to get squared away. So if that's all squared away, you don't need to be back on 5/12 or rely on Mr. Catalinic. Once you do your intake with pretrial, then they'll file the stuff and it'll be squared away. But if we don't set it on a status, then sometimes they, you know. All right? All right, very good. Thank you now. Good day.
That's all I have. Thank you, sir.
Thank you, Mr. Catalinic. Good day. And who has, Montanero de Jesus? Is that?
Oh, that's,
And I got an email regarding the continuance, and that's agreed to
That's
because
correct,
of
Your Honor.
the
Yes,
plea negotiations.
I wasn't able to review that report until later. I sent them an email on Friday, and so we're going to need to continue that, Your Honor.
All right, so the Montanero de Jesus is continued one full cycle to 5/12.
How you doing?
Judge, this is Kirsten Mann, in before the court, in two case numbers, 24 CF 1944 and 25 CF 23, examining potential crimes. I've reviewed the plea agreement in this matter with Ms. Mann. I believe she's previously discussed the terms of Mr. Klein. At this time, she will be withdrawing her previously pleaded not guilty and pleaded no contest as charged. The agreement, as I read it, is time served on misdemeanors and 2 years probation on the felony counts. All the misdemeanors are going to be time served. In each of the count ones, which are the felony petty thefts, there's going to be 2 years probation concurrent, 24 hours community service, no trespassing in any Walmart while on probation. She must attend a complete shoplifter's awareness class. Madam Clerk, I wrote in $615 in court cost, or $515 in court cost. $50 application fee and a $100 public defender fee times 2 for a total of $250. She will be adjudicated guilty on all counts in both cases. No objection to the score sheet, which reflects 18.7 points. May I approach?
Granted. Fines, fees, and costs correct, Madam Clerk? All right. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, and you can put your hand down. You heard what Mr. McKinney said on your behalf and signed the written plea form?
Yes, sir.
All right. How old are you and how far did you go in school?
41, some college, I didn't graduate.
All right. You able to read and understand the plea form?
Yes, sir.
And did you do that before you signed it?
Yes, sir.
And is what Mr. McKinney announced what you read in the form?
Yes, sir.
All right. In this case, do you understand that you're pleading no contest to the announced charges?
Yes, sir.
And by doing that, I understand you to say you believe the state could prove your guilt and you're not going to contest that.
Yes, sir.
Do you understand by making this plea, you're waiving your right to a trial by jury where the state would have to prove your guilt?
Yes, sir.
In this case, you'll be adjudicated guilty. And on the misdemeanors, it's time served. And on the felonies, it's 2 years of probation concurrent with 24 hours of community service, and must attend and complete the shoplifter's awareness class and have your fees and costs that you have to pay in addition to the other conditions. Now, also, you can't go back to Walmart.
Okay.
Now, I say this because I don't like setting a trap for anybody. You may think it's just that Walmart. Walmart says it's all Walmarts.
Yes, sir.
Okay? So govern yourself accordingly, because if they see you there, they're going to report it to your probation officer, and you're going to be in violation.
Yes, sir.
Okay?
Yeah, he explained that.
Okay. All right. And so with that, has between Mr. McKinney and Mr. Kleins, have they answered all your questions about the plea and how it affects you?
Yes, sir.
And are you satisfied with how they represented you?
Yes, sir.
Court will find the plea to be freely and voluntarily entered into and will accept the plea with the adjudication.
Mr. Watts? So just as Mr.
Good
Watts,
morning.
he's here in 2 case numbers. We're going to pass this over today as we were discussing a pay and dismiss situation. I've discussed it with Mr. Snell. We've come to terms on that. I believe we do still need to file the notice of assessment of restitution into the clerk file so the Madam Clerk has that dollar amount. So I believe that if we could put this on 5/12 for a control date, we have terms and agreement. Mr. Watts has the ability to pay. If we could just have the continuance until 5/12, we'll go ahead and make that happen.
All right. State?
That's correct, Your Honor. The state would agree with that.
All right, it'll be continued to 5/12 with the anticipation that once that information is done, that the restitution will be paid and the case will be dismissed. Is that right?
Yes, sir.
Okay, very good.
We'll keep hands on it to make sure that it happens well before then.
All right, very good. Thank you.
Judge, if we may recall Ms. Chantel Smith-Holman, who is present in the courtroom in 24 CF 120. Last name is Smith-Holman.
Good morning.
Yes, Judge. This was a situation where the alleged victim was served for a deposition on February 17th and failed to appear. I believe Mr. Snell has an update in this case.
Yes, so your intention is to take her deposition, correct?
Correct, and Your Honor, conversations from Mr. Smellitt evidently the alleged victim reached out to him. I have not personally spoken. Since that's the case, I would request continuance for that deposition.
All right. Is a continuous to 5/12 going to be sufficient time to get a case, to get the deposition done, considering the deposition schedule?
Judge, I do not know the answer to that. This would be my top priority, of course, but this is the first time I heard that the alleged victim is out there.
Mr. Snell?
I don't see why we couldn't have the deposition before then. That seems like it would be sufficient time.
All right. All right. So it'll be continued to take the victim's deposition.
So this is ultimately continued. How we do these depositions.
Now, if the victim fails to appear for the deposition, we'll be right back where we are next cycle. Mr. Snell?
That we would not wish to go forward at that point.
All right. All right, very good. Thank you.
Do you stand on that? I don't want to talk on the road. It's 5:12. Judge. If I may call Miss Kelly Rodriguez. She's present in the courtroom, Your Honor. And, Your Honor, Miss Rodriguez was scheduled for court on pretrial on 310, failed to appear.
Can we have a case number, please?
Yes, Judge, 24 CF 2362. Miss Kelly Rodriguez.
2362?
Yes, Judge, and that's a 24 CF 2362.
All right.
Yes, Judge, this was, my client failed to appear on that 310 court date. A KPS was issued. She's here in court. I do have a signed plea form that would resolve the case today.
All right. And now it's your plea agreement.
Yes. Yes, Your Honor. For Ms. Rodriguez, this will be a lesser included offense of petty theft, first-degree misdemeanor, Florida Statute 812.014. This will be adjudication of guilt, credit for time served, court costs, $150 in defense costs, and I believe the state, if I may approach the sign, please point out.
Is there a subsection?
Negative, I have 812.014. You need a subsection?
Yes.
I'll get you that subsection.
What's the charge?
Petty theft, first-degree misdemeanor. 812.014 subsection
2E.
2 echo. Thank you. Judge, may I approach the witness?
Yes.
Now, it's 2 echo. There's 2 echo. Thank you.
But I've got count 2. Do you know crossing count 2?
May we approach?
Sure.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
I did write in count 2, possession of drug paraphernalia, which will also run with adjudication of guilt, credit for time served. And I did have my client initialed by my handwritten in. If I may
Very good.
approach, Judge.
Granted. All right, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, you put your hand down. You heard what Mr. Koch said, and then he amended this to include count 2, which appears to be a scrivener's error. You understand by this plea that you're pleading no contest to the 2 charges that were announced?
Yes, sir.
That says to me you believe they could prove your guilt, and you're not going to contest that.
Right.
And you understand by doing this, you're waiving your right to a trial where they'd have to prove your guilt.
Yes.
In this case, it's adjudication of guilt, credit for time served, with the court costs of, what are they, Madam Clerk?
$270 plus the
And how much time will you need to get those paid?
Could I ask for 6 months or to a year, maybe?
I'll give you a year to pay.
And that was 250, you said, plus?
270 plus 150.
Okay.
Mr. Koch answered all your questions about the plea and how it affects you?
Yes, sir.
You satisfied with how you've been represented?
Yes, sir.
Court will find the plea to be freely and voluntarily entered into, accept the plea, and with the disposition of this, the court will withdraw the capias, direct that the estricture be withdrawn, and the forfeiture be withdrawn as well.
Thank you, Judge.
All right, thank you.
Thank you.
We'll just get fingerprinted, but you're all good.
Judge, there is a Luis Tamayo Correa
Yes.
in the courtroom. He is pro se, and he does need the services of having an interpreter in his presence.
All right, Madam Interpreter, raise your right hand. Do you swear to interpret these proceedings truthfully, adding nothing and subtracting nothing? All right. So you're here today without an attorney. Would you like an attorney to represent you?
I don't have an attorney. If I could get a public defender assigned?
Yes, sir. You'll have to complete an application for the appointment of the public defender. Do you need the help of the interpreter to do that? No. She has some other people she needs to talk to, so it may be a minute before she'll be able to sit down and help you. Is there an offer on Mr. Tamayo Correa's case?
Yes, sir, there is.
Why don't you announce that so the PD can be prepared?
Adjudication of guilt, credit for time served, or withhold of adjudication, 2 years probation, substance abuse evaluation, treatment, 24 hours of service, no alcohol, drugs.
And this is a POCS and 2 counts of POP.
Yes, sir.
All right. I didn't see that. Did it say more right? All right, it looks like he already completed the form once and was denied, so maybe I need to ask him some questions.
Yes, sir.
And you live in Jacksonville, is that right, sir?
No.
Okay, because you listed your address in Jacksonville. Where do you live?
Sí, pero cuando vine la semana pasada dije que me había mudado.
Last week when I was appeared here, I announced that I have moved.
Okay. And where are you, so you're no longer employed where you were?
¿Usted ya no está trabajando? ¿No estaba trabajando
Sí.
anteriormente? Yes.
My work is move.
So his work moves him to different places?
All right. And the income you listed, is that what you take home every week?
¿Usted completó en su aplicación anterior es lo que usted gana cada semana?
Sí, 800 y pico semanal.
Approximately 800 a week.
All right, and that's what you take home?
Y eso es lo que usted se lleva a su casa libre.
Bueno, tengo que pagar renta, hotel.
I do, but I'm required to pay rent and hotel.
All right, but I understand that, but that's what you take home? After your taxes, after all your insurance, are you self-employed and you're responsible for your own taxes?
¿Usted es responsable de pagar sus propios impuestos? ¿Está
Sí.
empleado por sí mismo?
Sí.
Yes.
So you get paid the
¿Usted se le paga?
$800 and then you have to pay your own
¿Tiene que
taxes?
pagar sus propios impuestos?
Sí.
Yes.
Okay. Just a second.
Deme un momento.
And other than yourself, you're obliged to support two other people?
Aparte de usted, ¿usted tiene que mantener a dos personas más?
No.
No.
Okay, because you listed on your form that you have two dependents.
En su aplicación usted
Sí,
es
pero-
responsable por dos personas más.
Sí, ya me separé.
I've separated,
Yes.
and that's my ex-girlfriend.
Okay, so you don't have any dependents?
No.
Okay. So you would not qualify for the appointment of the public defender based upon your income?
No sabemos ingresos.
So you'd need to hire private counsel,
Usted tendrá que contratar su propio abogado.
or you would need to complete the form and talk to somebody about what your actual income is after lawful expenses
Puede intentar completar a través de la aplicación y explicarle a alguien cuáles son todos sus costos y
as provided by the statute.
cómo se aplican a él.
As you're self-employed,
Como usted trabaja para sí mismo,
required to pay your own
usted
taxes,
es requerido de pagar sus propios impuestos.
someone who could give you advice on what your actual net income would be
¿Cuánto es lo que usted lleva a su casa ya libre de impuestos?
could help you complete the form
Ayudar a completar el formulario
to see if you would qualify.
para ver si usted califica.
You have in effect listed your gross income,
Usted puso en su aplicación el ingreso neto.
your net income for purposes of appointment of a counsel
Su ingreso neto para propósitos de que le asignen un abogado de la defensa pública
is what needs to be on the
es lo
form.
que tiene que estar en su aplicación.
I'm not able to calculate that for you
Yo no puedo calcular eso por usted,
based upon what you've told me today.
basado en lo que usted acaba de decir ahorita.
I'll continue the case to give you the opportunity
Le voy a aplazar su caso para darle la oportunidad
to talk to someone about that
sobre eso.
and have you complete the form
El
again
formulario una vez más.
after you speak to them and they can explain to you what your income should be after all lawful deductions.
Usted reduzca todos sus costos legales.
Okay. So if you'll take the form with you and get someone to help you with that,
Preguntar a alguien que le ayude a
and then turn it back into the clerk.
entregar a la secretaria de la corte.
With that, I'll continue the case to
Voy
5/12.
a aplazar su caso para el 12 de mayo.
Okay?
Okay.
Now, you filled out, did he fill out the information form last time? Yes. Okay. All right, so we have your current contact information.
Yo estoy en un formulario completo.
Do you have any questions while I have the interpreter here?
¿Tiene alguna otra pregunta mientras estamos aquí con el intérprete?
Ya, ya, ya.
No.
Okay, thank you very much, sir.
Muchas gracias.
I
Judge, this is Jaleese Williams before the court in 3 case numbers, 24 CF 1687, and 2 felony violations of probation, 17 CF 2750, and 17 CF 2190. The agreement that we have reached is that in the 24 CF 1687, count 1, which is the felony count, will be dismissed by the state. Mr. Williams will be pleading as charged in counts 2 and 3, which are each first-degree misdemeanors. To those, he's going to be placed on 12 months probation concurrent with an adjudication of guilt. Even though they are misdemeanors, we're about to announce that his probation is reinstated. So it will be courtesy state supervision for these 2 counts on 24 CF 1687. The felony violations of probation would each be an admission to the violation of probation, and his supervision would be reinstated to complete the original requirements. Total is $270 court cost, a $100 VOP fee, and each of the VOPs for a total of $200, and a total of $350 cost of defense. May I approach?
Granted. All right, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, and you can put your hand down. You heard what Mr. McKinney said, and you signed the written plea form?
Yes, sir.
All right, now you got 2 things going on. You got your VOPs and your new charges. We're taking care of them today, but they're 2 different things, right?
Yes, sir.
Now, as to your VOP, you understand that you're admitting the violation.
Yes, sir.
And that says to me, Judge, I did violate the way the probation says I did.
Yes, sir.
Do you understand by making the admission, you're waiving your right to a hearing where the state would have to prove your violation?
Yes, sir.
And as to your new charges, do you understand you're pleading no contest to the new charges?
Yes, sir.
And by doing that, you're waiving your right to a trial by jury where the state would have to prove.
Yes, sir.
All right, your charges. And you're going to be reinstated your probation to complete your original terms. And you're going to be on 12 months of probation on the new charges to run concurrent with your reinstated term of probation. You'll have all your these costs coming out of these cases to be paid under the terms and conditions of your new probation. And I don't know how much time you have left on your old probation, but you'll have the full amount of that time to get all your costs paid. So you don't have to pay these costs in the 12 months. You'll have the full amount of time.
Okay.
Does that make sense?
Yes, sir.
All right. With that, has Mr. McKinney answered all your questions about the plea and how it affects you?
Yes, sir, he did.
Satisfied with what he's done for you?
Yes, sir.
Of course, find the plea to be freely and voluntarily entered into, and will accept the plea. Thank you.
Thank you, man.
Yes, sir. We're going to get fingerprints, and we're going to talk to probation on the way out. Good to go?
Sorry, I didn't realize. I thought you were having 2-year-old blowjob. Reyes? Gabriel Reyes? Judge, this is Mr. Gabriel Reyes in 24 CF 2929.
All right.
Judge, this is set for plea or continuance. I received a score sheet and offer from Mr. Snell. I spoke with my client on March 14th with an interpreter. I'm seeking a 1-cycle continuance to 5/12, knowing that next time will be plea withdrawal.
State?
No objection.
And is, because I know that on 310 last week, you told us we got the offer, and you need more time with him to discuss that, or for him to engage on the issues involved in the plea?
Yeah, that was the state's position or understanding that I thought we had it resolved.
We do need more time, specifically that ice hold. I need to discuss more with him. And I did tell my client I can bring him earlier than that 5/12 date if the circumstances change.
Tal vez más pronto de lo que si las circunstancias cambian.
All right. Are we delaying the inevitable?
Judge, on my end, the depositions are done. I got the offer,
Los abogados están diciendo que necesitan todas las declaraciones.
but I'd like more time
Necesitan más tiempo
to discuss
para discutir con usted
consequences of that
las
plea.
consecuencias de este
All right. All right. I'll continue. You can advance it if we have a plea.
Thank you, Judge. Yeah, we will talk about that.
Rivera?
This is Mr. Wilfredo, last name Rivera Gutierrez, in 24 CF 2650.
All right. I thought we were going directly to jury review on this one.
I was hoping that it would be to go with the companion case, because that would be ideal.
All right, so what are we doing today?
Judge, this was set for clear continuance. The alleged victim failed to show for a deposition on February 18th. We set it today as Mr. Snelka made contact. If not possible, we dismiss this today, Judge.
I had issued subpoenas out for them, so hopefully they will be here on the 21st.
All right, so we're going, that was my notes. We would go directly to jury review, and if they fail to appear on jury review, am I confused? Is this the?
Just for the Wilfredo Rivera Gutierrez case, I set it for documented clear continuance without subs, my understanding, due to the alleged victim failing to appear without deposition.
The state is going to request that it be, remain on the 321 to see if my witnesses respond to the subpoena.
Right, and if they fail, then you're going to MP the case.
Yes, sir.
And was this a case with a co-defendant? That's right.
Yes.
I know that's what you guys discussed. Okay.
All right, so we'll see on jury review.
Which is this Friday. If the alleged victim fails to show, they're going to dismiss the charges. Friday. I was hoping it was going to be today, but it's going to be Friday. Friday, they've had no contact with the alleged victim. The alleged victim failed to come to my office under subpoena. Uno Mas Eddie Rivera.
Yeah, he was just.
There you go. Judge, this is Mr. Eddie Rivera Torres and 23 CF 616. Yes, Judge. I first want to notate, this was a case that had a capias. My client was rearrested on January 30th of this year. I saw my client on March 14th with the translator. I had the offer and score sheet, Your Honor. I'm seeking a final continuance to 5/12. I'm requesting more time to discuss certain consequences of that plea.
What is the nature of the offer?
Currently, it's 1129 adjudication of guilt. And my client will become a convicted felon.
State?
That's correct. That's the offer.
And you agree with the continuance?
That's no objection.
Right, because I guess my concern is that as of Friday, it was 2 years old. So what needs to be done to have the case ready for trial next cycle? Because I'm not going to continue it again.
Judge, I don't need any depositions. I am working on some offers. But the additional time is mostly for those adverse consequences of the plea.
All right. All right, so based upon, and as I see it looking at this, based upon he was rearrested, looks like, on 1/30. And we had our first actually, I don't think we had him. We had him on 3/12 or not? I don't think we had him on 3/12, did we? We did, yes, okay. But you didn't have a chance to see him because of the arrest until, okay. All right, so I'll continue it with the idea that we will not have another continuance. It's going to trial or it's going to be pled at the next trial cycle. Okay?
Yes, Judge. This guy continued to make that really sooner. Further discussion. Yes. Thank you. So this is Mr. Antoine Carson in 23 CF 2766, 23 CF 1629, 23 CF 1952. Yes, Your Honor. We discussed my client's case briefly on pretrial on the 13th, Your Honor. Ultimately, I have the plea form score sheet, and I reached out to Ms. Dana Claw from the Emerald Coast Life Center. My request from this court is to enter the plea, delay the sentencing to the July 16th in custody pretrial date, so my client can stay in the Emerald
It's
Coast.
pursuant to our previous discussions.
Yes, Judge. And
Okay. What does the state have to say? July 16th?
Yes, Your Honor, but we would want to enter the plea agreement now, just
Yep.
so it's entered into.
Right. And your client's agreeable to that and understands the consequences?
If I could just have a brief conversation on Judge, thank you. Since we're delaying the sentencing, do you want me to list the terms, Your Honor? Or?
Yes, absolutely.
Yes, Your Honor. I want to notate that we'll be pleading as charged, except in 2023 CF 2766, count 1. That will be the lesser included offense of burglary of an unoccupied structure, and that's Florida Statute 810.02. The terms of the plea in 23 CF 1629, count 1, and in 23 CF 1952, count 1, we're going to admit to the violation. It'll be adjudication of guilt, 18.6 months, Department of Corrections, credit for time served. Probation will be terminated and placed on a new term of 36 months of standard probation. There's a $40 $40 per month cost supervision. Must successfully complete the Phoenix House program, bars to bed. No contact with Tracy McFarland. No return to 628 Ferretti Avenue, located in Fort Walton Beach, Florida, 32547. $200 for the cost of prosecution for the VOP, $250 in defense costs, and there's $50,000 in restitution to Tracy McFarland. In 23 CF 2766, count 1, adjudication of guilt, 18.6 months, Department of Corrections, credit for time served, followed by 3 years of standard probation, with the term to successfully complete the Phoenix House program, bars to bed. There's $515 in court costs, $100 in defense costs. In 23 CF 1629, counts 2 and count 3. 23 CF 1952, count 2 and count 3. 23 CF 2766, count 2. These are the misdemeanors, adjudication of guilt, credit for time served. All cases and counts to run concurrent. If I may approach the signed plea form and score sheet.
Granted.
I apologize. I will leave that.
What's the charge?
Burglary of unoccupied structure, 1002.
All right. Mr. Parson, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
I do.
All right, and you can put your hand down. Now, you heard what Mr. Koch said on your behalf, and you signed the written plea form.
Yes, sir.
All right. How old are you, and how far did you go in school?
I'm 31 and 10th grade.
You able to read and understand the plea form?
Yes.
Did you do that before you signed it?
Yes, sir.
And is what you read in the plea form what Mr. Koch just announced to me?
Yes, sir.
Do you understand by this? I think, I'm sorry, just hold on a second. I think I probably need to hold on to that score sheet and do that at the time of sentencing. Any score sheet objections?
No objection from
Okay,
defense.
pass that back to the state and we'll grab that at sentencing. So you understand by this plea arrangement that you're pleading no contest to all these charges?
Yes, sir.
And that says to me that you believe the state has the evidence on the new charges to find you guilty and you're not going to contest that.
Yes, sir.
As to your VOPs, do you understand that you're admitting the violations?
Yes, sir.
And that says to me that, Judge, I admit that I violated my probation just the way the affidavit report says it did.
Yes, sir.
All right, and by doing this, you're waiving your right to a hearing where the state would have to prove that violation.
Yes, sir.
Okay. Now, in this case, you're adjudicated guilty, and the sentence will be the 18.6 months Department of Corrections, terminate your existing probation, put you on a new term of 36 months of probation, with the condition that you'll enter into Phoenix House, bars to bed, and successfully complete that program in any aftercare, no contact with Tracy McFarland, and not go back to the address that was announced, plus the fees and costs. Now, that sentence is not being imposed today. If, when we come to sentencing on 7/16, you have no new charges and no new violations, the court will impose this sentence on you. If, on 7/16, you have new charges or new violations, then the court is not bound to impose this sentence, but could impose any lawful sentence. Do you understand?
Yes, sir.
All right. Now, with that, as Mr. Koch explained all this to you and answered all your questions,
Yes, sir. My bad.
and you satisfied with how you've been represented,
Yes, sir.
the court will find the plea to be freely and voluntarily entered into, will accept the plea, and will set the matter for sentencing on 7/16. All right, thank you.
And that's, I believe it's 81002, subsection 1, subsection B, subsection 1.
Thank you.
Robert Riddle.
Good afternoon.
Good afternoon.
Judge, this is Mr. Robert Riddle on 24 CF 1789, 21 CF 961. Judge, we were set this today. As I said before, alleged victim failed to show on February 26th. Mr. Snell this morning, I don't want to put words in his mouth, the alleged victim showed up to court this morning.
So she responded to a subpoena. So it turns out the subpoena for her deposition went to the wrong address. So, but I have all of that information.
All right, so what's the outcome today?
Judge, defense is asking for the 512 continuance, one cycle, so I can depose that alleged victim.
All right, and when is that deposition going to be taken?
Judge, I'm going to try before 512. Like I said, I just found out this morning that the alleged victim showed up, but my intention is to get that deposition finished and finalized. That's the last outstanding thing in this case.
All right.
I'll do everything I can to get that scheduled right away, so.
All right, because by the time we get there, the case is going to be 9 months old. So, and based upon the nature of the case, I realize that it could be a complicated case depending on what the witness has to say. But it could also, based upon the reading of the addendum of probable cause, not be a very complicated case to try. So I guess you see where I'm coming from, Mr. Cox. I could see your reaction that you saw. It just depends on what the witness has to say at the depot, but and the other case is the VOP, right, which is based upon this new charge.
Correct, Judge.
Okay? So based upon the victim's failure to appear on 226, that needs to be a priority based upon the age of this case. See what it says. I'll continue it. I'm really on the cusp of whether I'll grant another continuance after that. This case is old. It needs to be tried.
Yes, Judge.
And because of the nature of the charge here, the defendant is not entitled to bond. And so I'm just uncomfortable continuing the case after 512, after the deposition of the victim. All right.
Yes,
So the case needs to be resolved.
Yes,
because the underlying charges, right, let me double check that. To be sure. Right, because the underlying charges don't qualify him for VFOSC, but this charge does. So if this charge is going to be resolved, it needs to be resolved because he'd be entitled to a bond otherwise. So we need to make sure that victim gets the deposition taken ASAP so that you can make a determination of how to proceed in this case. And like I said, I'm on the cusp of whether I'll grant any further continuances. The case needs to be resolved one way or the other.
Yes,
okay?
Judge.
All right? And I'm not suggesting that's your fault, the victim failure to appear. So my point is the case needs to go.
Yes, Judge.
All right.
Judge, may I have just a brief moment?
Absolutely.
Judge, this is Mr. Michael Rona in 23 CF 1819. If I may have a brief moment, Judge.
Yes, sir.
Yes, Your Honor. Thank you for that brief moment.
Yes, sir.
My client wishes to move forward with trial, Your Honor.
Okay. And if we have a trial, how many days do you think it'll take to try the case?
Judge, I'd say one independent jury selection. State would like to put on the record, they did review the case on Friday and contemplated filing additional charges if the defendant did not wish to plea. We did receive indication from Mr. Cox that he was going to plea, so we did not file that amended information, but we will be doing so.
All right. Will the amended information change the credibility of trying the case this cycle?
No, Judge.
Okay. You agree, Mr. Cox?
I agree with Ms. Barickman, Judge. She was, we were fully aware and even aware today.
All right, so the longer I do this, the more often I say this, right? A judge gets a snapshot of these cases when you show up. I have no clue what those additional charges are. Tell me so that I can inquire of the defendant to be sure the defendant's aware of what's going to happen, and this decision to go forward from today is a free and voluntary one with the understanding that after today, it would be no plea other than guilty as charged, including the new charges. So what are the new charges?
It would be an additional count of solicitation, Judge.
Okay, and help me understand, is that based upon the facts already in place in the addendum of probable cause, or are there additional facts outside of that that give rise to the additional solicitation?
It was within the original report and the evidence provided to defense.
And so the state originally made a decision for one count, but after reviewing and understanding, the state believes that 2 counts are appropriate and supported by the facts of the case.
That's correct, Judge, and that would take guidelines up to 44.7 months as a presumptive sentence and a maximum of 15 years.
And the current plea offer is 5 years of Department of Corrections, followed by 5 years of sex offender probation.
After the last court date, state had discussed with Mr. Koch and had agreed to do 4 years in the Department of Corrections, followed by 1 year of sex offender probation. However, that offer will be revoked today.
So it was 4 years followed by?
1 year.
All right. All right, and you've discussed, Mr. Koch, the consequences of the amended charges and your client's decision not to accept the plea offer, and how after today, the only plea the court would accept is a guilty as charged?
Absolutely, that was explained. And just to follow up Ms. Barickman, that 4-1 offer was a plea to count 1, just to clarify the record, and count 2 would have been dismissed. I just want to notate that on the record. But my client was fully aware. After today, it'll be, if you want to enter a plea, it's going to be plea as charged to the bench. And with the amended charge, maximum exposure of 15 years, and the score sheet being adjusted with those amended charges, will be a minimum guidelines of 44.7 months, Judge.
And you've explained to your client that the presumption is that the sentence would be no less than the 44.7.
Absolutely.
Okay.
The guideline sentence would be the minimum.
And with that, raise your right hand, please, sir. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, Your Honor.
Okay. Now, you can put your hand down. All these questions are designed to be sure that you know and understand what you're doing. And to know and understand what you're doing, you have to have the information to make that decision. And so you've heard what the state intends to do, which is the additional charge,
Yes, sir.
which changes your guideline sentence, which is the presumed sentence you will receive, to 44.7 months. in the guideline sentence. And with a maximum potential exposure with the 2 counts of solicitation and the 1 count of the two-way device of 3 5-year sentences for a maximum potential of 15 years.
Yes, Your Honor.
All right. And you've instructed your lawyer to reject those offers and go to trial.
Yes, Your Honor.
All right. Now, when the parties, when the state and the defense reach an agreement on a voluntary sentence, the court seldom, if ever, goes behind that agreement. There are some times when I do. But I don't know everything about the case. The court relies on the lawyers to examine the case and make an agreement which, under the circumstances, represents a fair and just outcome as far as the parties are concerned. When we get to trial, I'll learn everything about this case and about you. I may find that the 44.7 months is an appropriate sentence, or I may find, based upon the facts and the circumstances presented, that the 15 years is appropriate. Ultimately, the decision on sentencing will be up to me. And anything between the 44.7 to the 15 years would be a lawful sentence. Do you understand that?
Yes, Your Honor.
And once after the trial, if the jury returns the verdict of guilty, the sentencing then is completely up to me.
Yes, sir.
All right. And so you feel under the circumstances presented, the best decision for you is to go to trial and require the state to prove your guilt.
Yes, Your Honor.
All right. And you've discussed all this with your lawyer, had your lawyer answer all your questions about why it might be good to go to trial and why it might be good to accept a plea?
Yes, Your Honor.
All right. And I don't want you to tell me what your lawyers said to you or the advice your lawyer gave, but is your decision to go to trial consistent with your lawyer's advice?
Yes, Your Honor.
It is. Okay. All right.
Judge, we have a brief, kind of just a brief moment.
Yes.
Thank you, Judge, for that.
You're welcome, sir.
You're speaking to my client. He had no further questions for me and wishes to move forward with the trial.
Okay. And just to confirm, we believe that 1 day plus jury selection, and how many jurors, considering the nature of the charge, do we think we need?
We'd ask for 60, Judge.
You agree, Mr. Koch?
Yes, Judge, I agree with the state.
And I know we had that discussion about the group pick. I probably will not group pick this charge because of the nature of it.
Yes, Judge.
Okay. I mean, it'd be difficult to get our 6, you understand the reason.
Absolutely.
And you can discuss that with your client. That doesn't affect you individually. It has to do with how I manage jury selection. And because of the nature of the charges, I don't want to pick your jury with other jurors. I want to provide an isolated pick because I'm concerned that if I do a group pick, that may somehow or another have an impact on the jurors that we pick for your case. So I want to be sure you get the absolute fair jury and an opportunity for Mr. Koch to pick a jury that will try your case fairly, okay?
Yes, sir.
Okay, so we'll see you then on jury review.
All right, Michael, see you on Friday.
Is that something?
Judge, this is Mr. Nathaniel Seaborn in 24 CF 2712.
Yes.
Set for today, as I stated before, Judge, the alleged victim did not appear for the deposition on February 26th.
Yes.
I'll turn it over to Mr. Snell.
Yes, Judge, if we can leave this one for the 21st, I have subs out on that.
Me too.
All right, so if the victim shows on the 21st, what are we doing? So I had it set for today.
So if, may we approach?
You may approach.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
All right, so you don't need to be here on Friday. We're just going to set it for status, and your lawyer will let you know. Okay?
Judges, Mr. Eric Silvas in 24 CF 2717.
That should be already in all frost, Your Honor.
All right, very good. Thank you.
Yes.
Yep.
Judge, this is Mr. Darren Taylor before the court, and 25 CF 100 is our operative case. There are 4 violations of probation which we're tracking along with. In this case, we did file a demand for speedy trial on the 12th of March. I see that it's docketed, and we are in court on the 17th of March, 2025. We remain ready for trial.
All right. And so then just let's look at our trial, right? At this point, we look like we've got Ms. Rudisell, Mr. Gamble, and Mr. Rona. And how many days do we expect it'll take to try Mr. Taylor
I would
on
say,
the 100 case?
I would say 1 day plus jury selection.
State, you agree?
Yes, sir.
All right. So we want to go ahead and just set that the second week?
Yes, sir. The second week is far out as I can. I don't have my, obviously that's the issue, is I'm waiting on the report from FDLE, so. I believe you have pretrial detention date on the 3rd. If we could set this for a violation of probation hearing on the 3rd, and then set it for trial the following week.
All right. So, and how, say 1 day plus jury?
Yes, Judge. The defense is fine with the second week.
And how many jurors do we think we'll need?
Given the subject matter of the trafficking charge, I think a little bit more than normal would be necessary for this type of a case. I think 40.
All right. Right, because this is a first degree, right?
Yes, Judge.
All right. And so what about the 3rd, the afternoon of the 3rd for, if we set that at 2 o'clock, would that be enough time on the afternoon of the 3rd for the VOPs?
I believe so.
Judge, we would ask just to hear the violation of probation at the same time as the trial. And given that a lot of the witnesses are going to be the same related to the new charges.
No, sir. We would like to have a violation of probation hearing first, and then we'll have the trial.
We'll set the VOP. I guess my concern with that is as follows. The VOP is a non-jury proceeding, is evidentiary. The amount of the input there at that week, which we don't have other jury proceedings. I'm concerned about running up into a time constraint with all the jury and everything that's going on. So I prefer to try the VOP on 4/3, and that way we can focus on the jury trial the following week and take care of all that business at one time. I just think that that's more prudent. If I didn't have the other cases piling up and having the 60 jurors come in and all the other things that I have to do, I would accept that because, you know, Mr. Kinney, I've done that a number of times in the past. But I think with the other cases on the docket, I think it would not be prudent for us, and we end up getting jammed up with time to pick the jury and try the case at the same time. I think that this is more prudent.
The defense understands the court's concern.
Yeah, so we'll set this at 2 o'clock, the VOP at 2 o'clock on April 3 for a VOP evidentiary on 22 CF 2182, 22 CF 1746, 21 CF 250, and 19 CF 2910. And the trial would then be set the week of 4/7, which is 25 CF 100. And we'll figure that out Friday at jury review and look at the timing of the trials, which cases go, and figure out which day of that week we'll do that.
And the jury review is the 21st, this Friday?
Yes, yes.
So Mr. Taylor will be back in court on this Friday, and we'll talk about the schedule.
Correct. Okay. Yes.
Thank you, Judge. Are we done with Mr. Taylor?
Yes.
Judge, this is Ms. Tracy Rosado before the court. Ms. Rosado is before the court in 23 CF 457.
Yes, sir.
Judge, what I would like to do is procedurally ask for a continuance, but I'd like to put this on for a plea on this Thursday if the court will allow on the arraignment docket. That would allow me the additional time that I need to make sure that Ms. Rosado has absolutely no questions related to the plea, and that we can hopefully have a solid plan forward for Ms. Rosado upon a potential release. There will be designations that are serious in this case and will be able to affect where she is able to live and stay, especially if she is going into some sort of a program. I think that's consistent with the recommendations from Dr. Livingston's report, which is the court's last evaluation from September of 2024, and that she needs additional time, and that court proceedings and our communications need to be at a slower pace, repeated and highlighted.
Correct.
So I'm going to try to maintain that as best I can to make sure that there are no questions upon entering a plea.
All right. I will continue it to 5/12 and set it for a change of plea on 3/20. I just asked Mr. McKinney, since that's arraignment day, that you send a notice with a copy to Ms. Natali so that she can be sure to have a docket for us, because it won't populate on the arraignment docket.
Yes, sir. I will provide a notice for that, and I have budgeted effectively all day Wednesday to try to make sure that there is no stone left unturned, and hopefully we will have the information we need from a treatment provider to move forward with the plea on Thursday.
All right. All right, very good.
Judge, this is Lisa Walker. She is here in 3 case numbers, 23 CF 2470, which is a PTI recall case. That's why it's a 23 case. She has a 24 CF 2108, and she also has 25 CF 212, which Your Honor saw in arraignment on March 13th. We'd set it today in hopes that we could reach a global agreement with the state. She did enter a plea to the misdemeanor downstairs. We were unable to reach that global agreement for today. I believe the state does an additional obligation on the 25 CF 212 case, and then that might be the last step before entering a plea in these cases. So procedurally, I'm going to ask for continuance until the 5/12 date, but I'm certainly going to keep hands and try to resolve this as quickly as I can.
Very good. All right, see you then. Thank you now.
Get you.
All right. All right, so I've got, who you got left, Madam Clerk?
The only one I have is last name is Mosley with the PD.
That is Mr. Klein's case. I'm covering for Mr. Klein's. I've sent it the hallway.
Your Honor, the state requests KPs.
All right, issue a no bond capias. All right. So, and I had Muscle White.
That was a PTI, Your Honor, that should have been filed.
Okay, so it's squared away?
Yes, Your Honor.
All right, let me run down the rest of my list here. Teresa Lilly?
That was continued, Your Honor, to 5/12.
Okay. Because I guess that's the one where we did the capias and then it was withdrawn, right?
Yes, Your Honor.
Right, so we, okay, that's my bad. Then Brandon Preston?
That case was dismissed. We filed a null pros on that case on Friday, Your Honor.
All right, so what I show then as far as, and I know we'll be here on Friday to review this again, but I've got Carrie Rudisill, I've forgotten how many days we were saying, 1 day plus?
I believe so.
Standard number of jurors?
I believe, yes, from defense, that'd be my position, Judge.
And then I've got Mr. Gamble, which we announced 2 days and 40 jurors.
That's correct, Your Honor.
Then Michael Rona, 1 day and 60 jurors.
Yes, Judge.
And then Darren Taylor, 1 day, 40 jurors. And plus, we have the VOP on 4-3. So we got 1, 2, 3, 4 at this time. Right?
Yes, sir.
All right, so now, as I said before, I think